within which period you must bring the money to the bank, otherwise it's foreclosed. Would you agree to that? Would your client agree to that?
As long as we have 6 months from the date of the order of this court, in other 6 months, I'll assume, I'm not suggesting, but if you gave your decision today, we would ask for 6 months from today in which to pay. And if we don't pay within those 6 months, then obviously the order for foreclosure is made absolute. But we do need time to make the payment.
So you are pressing then. So just to be clear,
yeah.
What you're saying is that the relief that you seek is an order taking effect from the date of the judge's order at first instance, but that the order nisi would last for a period of 6 months from the date of the announcement of our order.
Exactly right. Although I should caveat that, which is our primary relief is that we should have the order for foreclosure set aside. But then how do you answer the fact that the bank would lose its security if that relief was granted? I agree. I don't, and this is my answer. So that's our secondary. Right. But formally, we asked for that.
All right, well, let's go back to where we came in, which is when I asked you about the plethora of defences. And the primary proposition you wish to put is that an order nisi should have been granted instead of an order absolute. Now, if that proposition is right, we will accede to it, and you'll have got what you wanted. So what are all the points about adjournments and denying legal representation? What's all that got to do with it? Because either the point is good or it's not, and if the point is good, we'll fix it.
Yeah, well, the other point, I agree. There are a couple of other points, which is the one that would be dealt with by Mr. Taylor, which is a reference to the USC. But if you're with me on this point, we don't need to deal with that. And similarly, I would accept that if you're with this, which is the core, with us on this, that's the core of the case. There are other points about, for example, there is the issue of Abu Dhabi Commercial Bank and whether or not it had a mortgage or whether there was evidence before the judge at the time. We now know there wasn't, but that gives rise to an issue. But if you're, I totally accept that if you're with us on this point, that's it. We succeed and we will be happy with the result. So I see that.
Montague Smith can persuade the client to accept that.
Let me just say, the difficulty that we have with this proposal is not that this particular proposal has been put before, but what we have seen is, you know, the offer that was referred to at the last hearing, you may recall, from Omniat. Do you recall that? And then what's been disclosed is an agreement between Al Rihab and Omniat. And so the agreement between Al Rihab and Omniat sets the price at a particular level, and it says that what will happen is that Omniat will purchase the property at a particular set price, not an open market sale, an off market sale. And what we've understood from Al Rihab's position is that would be a sale at an undervalue, and it's also a sale to a shareholder of Al Rihab. Now, under the terms of the Common Terms Agreements, Al Rihab is not permitted to sell the property either to a shareholder or at anything other than arm's length terms. And I can show you the provisions of the Common Terms Agreement, but it also features in these other documents that have been disclosed by Al Rihab.
For myself, Mr. Montague, for myself, I'm looking at from a different angle. Mr. Vernon's client will go to the potential buyer, whoever it could be brother, mother, or wife it is, collect the money with an undertaking given by the bank that the moment they see cash on the table, they will do foreclosure. They will allow to redeem the property. That's all.
Yes.
Then the is off agreement is by consent. Your client, Mr. Montague Smith, gets his money. Mr. Vernon's client gets his land. Everybody is happy.
Mr. Montague, let me see if I've got it.
They cannot have the money on the table. Then you walk away with the bank walks away with the property.
Sorry, I missed
order that.
I think Justice Martin's about to say something, and then perhaps I can
Mr. Montague, as I understand, let me see if I've got it right. Your position is that Al Rihab commenced defaulting in 2016,
Correct.
Defaulted in payment of principal in 2016, defaulted in payment of interest in 2017.
Correct.
And therefore had 3 years in which to rationalise the position and sell the property. It didn't do so. These proceedings were started in April and it was served in April. The orders were made in June and there was a lot of flurry of activity in June. And the only thing that's happened between June and now is that in November, a transaction with a related party was identified, which transaction cannot be completed without breaching the security documents, and also requires the consent of the DIFC Investment Corporation, which doesn't appear likely to be forthcoming. And therefore, any further postponement is not going to achieve anything. Have I got that right?
Yes. And the other part of it is this, that the situation as we have it with the order will achieve the same result as if Al Rihab went to the open market to sell the property. Why is that? Because there is no prospect of the bank retaining any windfall. If the property is worth more than the combined cost of paying off the mortgage, number one, and paying back DIFC investments, then any surplus that is recovered will have to be paid to Abu Dhabi Commercial Bank. If Al Rihab goes to the market to sell the property, any surplus that is recovered will have to be paid to Abu Dhabi Commercial Bank. So all that matters is how much you get for the property. And what is happening? Sorry, go on.
No, well, what I understand has happened, unlike the situation at the time the judge made the order at first instance, the undertakings that you are now proffering are in effect converting what was an order for closure into a process that will be, in practical terms, identical to a mortgagee sale, with one apparent exception, I think, and that is that neither of the alternative forms of undertaking you proffer actually includes any undertaking to sell. So they're undertakings as to sell, and I would assume using the endeavours that would apply, same standard of care that would apply in a mortgagee sale and within a reasonable time.
I would just need to check with my client, yes, but I cannot see any difficulty with that. Can I just make one point though, yes, which is this, that in relation to the application of the funds, the surplus, and that being paid to Abu Dhabi Commercial Bank, we're happy to give that undertaking, but the obligation to pay that money to the bank is not the result of that undertaking. It's the result of my client's obligations under the Common Terms Agreement, and in particular the Application of Payments Agreement, which is always in place. There has never been a position where Emirates Bank would retain any surplus in this property. But yes, sure, if that needs to be reinforced by undertaking, we will do that.
Yes. Yes, all right. Well, I understand. Thank you.
Thank you.
So can I come back on that, because it's clearly something that concerns the court. What we submit is this confuses two different issues. The first issue is what is the principled approach to foreclosure, and we submit.
Mr. Vernon, do you agree to what Justice Swain and Mr. Montague Smith has been discussing just now? Do you agree with that?
No, we don't. We don't agree with that. What we ask for is 6 months to make the sale and to repay the debt to Emirates Bank. That's what we're asking for. And we submit that there's no reason not to do that. What has happened is undertakings have now been offered that weren't offered to the first instance judge, and that confuses in our submission the issue of principle with the issue of the underlying sale. So in our submission,
forget about the law. Forget about the law. Forget about the law.
Okay.
I'm trying to say that both parties. I'm trying to say this is my part of it. Is the bank get its money, and then maybe another additional 40 million for the IFC that you're owing as well, plus that one, and then you get back your bank, because I think Mr. Montague Smith, you did state just now that your client is not taking or expecting to take whatever balance of the purchase of the sale price. They just want their money. What is owing to us, pay them. That's all they want, isn't it?
Correct.
And if that is the case,
can your client bring whatever amount it is, plus interest, plus the amount owing to the IFC, plonk on the table of the bank, and then the bank will grant you back the foreclosure, the title, and then you go back on your merry ways. But if by 12 o'clock on that day, the 12 midnight on that day, your client does not come with the money, then that's the end of the story. The bank walks away. And when the bank walks away with the mortgage, then they can do anything they like with the land. They can sell below price, they can keep, they can do anything they like with the land. What do you say to that? What do you say to that? But if you agree to that, we just record a consent order and finish off. Because Mr. Montague Smith, even if you don't give them the 6 months, by the time things will drag on a year and somebody will file another application, a stay, blah, 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 another 2 years, nothing will happen. That happens. Huh? Mr. Brennan?
Yes.
Please.
All we want is the 6 months. And we accept that if there isn't a sale made by the end of a 6-month period from today, if today is the day you make the order, then the order becomes absolute and the bank takes the property. But we want those 6 months to effect a sale. If we're right, we will effect a sale and the Emirates will be repaid. And that's the only legitimate interest they have. And that's all we want. We just want our 6 months.
What do you mean by that? What do you mean by that? What you are saying is, while the property is mortgaged to the bank, you want to borrow the property and sell it? Or what is that? What do you mean by that? I'm not very clear.
We want to sell my clients want to sell the property, as you've seen. They've taken steps already to try and sell it in the context.
But you've already entered into a binding agreement to sell it, haven't you?
Yes, subject to the conditions in the agreement. Yes.
Yeah. But that agreement, according to Mr. Montague Smith, can't be lawfully performed consistently with the security documents to which your client is a party.
And we don't agree.
So you don't. Well, I'd like to hear you on that in due course.
Yeah.
But if you've entered into an agreement, and what do you say also about the value issue? You've entered into an agreement to sell it for 108 million dirham. Earlier, you put on evidence to the effect that the value of the property was somewhere between 170 and 205 million dirham in its present state, and with subdivision the value was capable of being increased to 300 odd million. So on the face of your own evidence, there appears to be a sale under value to a related party, doesn't there?
Well, can I say that it's because of the way this has arisen, it's actually very difficult to deal with the detail of the sale because it only came in the last round. If it's to be said that this sale should be restrained, in other words, this can't be permitted, that doesn't detract. And we don't accept that for 1 minute. We submit that we're entitled to the 6 months to try and sell the property. And that's what we should be given. And if at the end of the 6 months there isn't a sale, and if indeed Emirates apply to restrain the sale, then the court can then consider in all the circumstances whether or not that sale should be permitted. But in my submission, it's plain that this confuses the issue of principle with the issue of practicality. In our submission, we are entitled to have 6 months. What is said against us is, well, in those 6 months, you couldn't make the sale. We don't agree with that. We don't accept that we're a related party. We don't accept that it's at an undervalue. We don't admit that at all. But the real answer is the only legitimate interest that Emirates Bank have is to be repaid their debt, and this sale would repay their debt, and that's the issue. Now, if they're saying that they have a basis for restraining the sale, that is not a matter in my submission for this appeal. That's a matter that they need to apply at first instance for, because it raises completely different issues. I mean, the great irony here, Justice Martin, is that our case was that the judge should have had everyone together. Any interested party should have come before the court to make their submissions. It was said against us that his approach to not doing that was quite right in principle. Now in the reply submissions, we have a lot of submissions which are directed to other parties' interests, DIFC Investments, about which this court knows next to nothing, about their consent, about the protection of the Abu Dhabi Commercial Bank's interests, when we were saying, and even submit today, that there was evidence that there was a second mortgage in favour of Abu Dhabi Commercial Bank. Now, in my submission, this court can't resolve the detailed issues of the interests of the various parties. What would normally happen, at the very most, is the order nisi would have been made by the first instance judge. The 6-month period would have allowed any party interested to come along to court and make their submissions and say why the order shouldn't be made absolute in that period. What's happened here is, our submission is the order for foreclosure shouldn't have been made, but now it's said that this court should resolve detailed issues about the sale process, the interests of parties not before the court, on the basis of evidence that you only have very limited evidence. Now, in my submission,
Mr. Flynn,
yeah.
Mr. Flynn, the only two parties that of which I'm aware who may have an interest in this property, and correct me if I'm wrong, but they are the DIFC Investment Corporation and the bank, the bank that was described, I think, inaccurately as a second mortgagee. Now, both of those parties have been given notice of those proceedings, and neither of them wish to be heard. Isn't that the position?
Well, Justice Martin, I don't accept that, because what you see in the reply submissions from paragraphs 4 to 30 is a detailed exposition of various other parties' interests. So, for example, what is being said on the appeal is paragraph 17, for example. I wonder if we can call that up. It is clear that any surplus should be available to Al Rihab's creditors. That would be the Al Jaber Group. You don't know anything about of any significance about the Al Jaber Group or their interests. You're told information about them, but that wasn't the focus of what happened below. Then in paragraph 19, the position of ADCB is protected without any court order. So what is prayed in aid against me is a variety of interest and security documents of various different parties. And in my submission, this court cannot resolve that issue. We say it's actually not relevant to the appeal because the appeal is an issue of principle. That is, should the foreclosure have been made, order have been made at all, or should there simply have been an order nisi to give time? We say that's the answer. The rest of it doesn't matter. The rest of it is for another day. If they want to bring this matter before the court, so be it. If they want to stop the sale, and this is what's so odd, because in our submission, the Emirates' interest is being repaid, and our solution gets them repaid. What they say is, oh no, maintain the order, because the interests of other parties, the Al Jaber Group, ADCB, DIFC Investments, these are all interests that they say are concerned, and their case is that it's fair to those other interests, and therefore one should maintain the order. Now, we don't accept that. We don't accept it's fair to others, and we don't accept that the court can resolve that issue, because it simply doesn't have the proper evidence and the opportunity of all those parties to come along and say what their position is. Now, why isn't it fair to those others? Why do you say it isn't fair to those others? The DIFC Investment is a creditor, isn't it? Yes, it is. Well, and the ADCB is a creditor, isn't it? It is. What's unfair about the creditors being paid? Well, it's not the creditors being paid, because the issue on this appeal is whether Emirates should be repaid. That's the purpose of the foreclosure. That was the issue that was debated. It's whether Emirates have a legitimate interest beyond them being repaid. I'm just testing the proposition that it's unfair, and it's difficult for me to see any unfairness in acknowledged creditors being paid their debt. But my lord, Justice Martin, can I say that the reason we object to that is because it's the wrong question. That would be an issue about whether the proposed sale should be restrained. I mean, that's a separate issue. What should have happened here, and what in my submission this court is concerned with, is whether or not there should be an order nisi, whether we should have 6 months. What happens in that 6 months is we would like to sell the property. Now, what's said against us is our proposed sale shouldn't go ahead. Now that, in my submission, is a very different issue, gives rise to very different concerns. It's not Emirates. Emirates is not advancing their interests because they are saying, because on our case, their debt will be repaid. The other issues are matters that would have to be ventilated more fully with full evidence, which just hasn't happened. To put it short, Justice Martin, in our submission, what happened here was an injustice. We didn't get the opportunity to put our case properly before the first instance judge. And had we done that, we would have had 6 months. That didn't happen at all. What's happened now is, it's as if that had happened and the court is being asked to take into account these other interests of other creditors on minimal information. And the reason there's minimal information is because of the way it took place at first instance. Now, if they have a case, and if they say this sale can't go ahead, which we don't accept, but if they do that, then that's a matter for an application for them. I would question why a bank who is going to be repaid by the sale would want to restrain the sale. But there we are. If that's the essence of what they say they want to do. They say that what we propose, the sale that we propose, isn't fair. In short,
well, as I understand it, sorry, Mr. Flynn, as I understand it, the commercial reason for that might be that in the event that proceeds are paid through to the ADBC, I probably garbled that acronym, but if it goes through to the second bank, then they receive it on behalf of a syndicate of creditors, which includes ENDB. So there will be a flow through from the second bank back to Emirates NDB. So there is it's not just prurient, it's not just noble actions on behalf of third parties. There is a self-interest in it as well, as I understand it.
As I understand it, Your Lordship may be right. Your Lordship, the problem that I have with this in principle is that the court's only being given part of the picture. And it's not an issue that arises in our submission on the foreclosure order. The 6 months to pay should have been given, and these are matters that should be raised in the face of that. In fact, what ought to have happened, if we weren't here now some way down the line, is the foreclosure order should have been refused. And the judge ought to have been told all of this. The great irony here, my lord, is that before Justice Giles, it was said this is very straightforward, you don't need to take account of anything. Our case was, no, there are other interests, particularly ADCB's interests, that should be taken into account, and we were told we were wrong. Now, much later down the line, this court is being told that it should take into account all of these various interests, the interlocking creditor agreements. I can't tell your lordships what the situation is on the basis of all those agreements. I don't know if you have all the agreements. I don't know how they interlock. I don't know what the interests of these parties are. And the court, in my submission, shouldn't be making decisions on the basis of that because it doesn't have the material, particularly when we say the unfairness was not doing that in the first place. In my submission,
let me get some facts clear. Who is the first mortgagee to the land?
I think it's EMBD, Emirates Bank.
EMBD, first mortgagee.
And that's the only mortgagee.
Yes. So, well, as it now appears, yes. There was originally, seemed to be...
EMBD the only secured creditor over this land. Right?
Yes.
Whatever creditors you have are unsecured.
Yes, subject to our arguments on whether a contractual document be sufficient. But yes, and the solution we're proposing means that Emirates will be repaid. The issue they raise is, but there are other potential creditors and other issues and so on, which should be taken into account.
Of the mortgagee. That's between you and the other creditors. They can block, they can garnish. They can garnish the money coming from the bank. If you had discharged your mortgage 1 year ago, you would have got a land, and the others are just unsecured creditors.
Yes, and that, in a sense, is what I'm saying, which is that it's what shouldn't have happened is that a foreclosure order should not have been made to transfer title to Emirates Bank. And we say, and one of the reasons we say that was wrong, there are many reasons why it's wrong in principle, is because the court should have looked at other interests to see whether that was appropriate and what the appropriate order was. And the most that should have happened is an order NISO with 6 months to pay, giving a final opportunity to my clients to pay the debt. The irony here is that what's said against me now is that originally it was no other interest needs to be taken into account. Now it's said the court has to take into account all these interests. Now, my client would want to contest that. If it's said that the sale shouldn't go through because it prejudices any other third party, we would want that proper opportunity to do that in the light of all the material and exactly what's being said. But what we do need is the 6 months to make the sale, and we want the opportunity to do that. And in my submission, it's the court can't assess whether the sale is a good one or a bad one. We don't accept that it's not at market value. Indeed, my clients will be saying that it's actually above market value. Now, this court can't assess that sort of detail on an application of this kind. And Chief Justice, you were right.
What difference does it make whether it's high, above or below the market value as long as the bank gets its money?
Well, I would gratefully accept that, but it's said against me that's not enough. I'm told that isn't enough. They're not saying the bank won't be repaid. They're saying that other creditors might suffer. That's their case. We don't accept that. We don't accept it isn't at market value. All we're asking
are they representing the other creditors too, or is there anything in the agreement? Is there anything in the agreement that?
I think Justice Martin's point is, which I think is putting it at the highest it can be, is that it might be said that Emirates have an interest in their own interest in looking to the interests of others. That's I think the highest it can be put. But the short point is this: we want 6 months. On our case, we're entitled to 6 months. If they want to try and restrain the sale within that period, which seems very, very uncommercial and very odd thing to do, but if that's what they want to do, so be it. Let them. We don't accept what they say. We don't accept that it's a related party transaction. We don't accept it's not at market value. But more importantly, the court can't determine that. You're simply not in a position to do that. And the reason the court isn't in a position to do that is because of the approach that Emirates took at first instance. When we were saying we wanted time, we wanted to get representation, we wanted to put the position before the court, it was said, no, this is very straightforward, just make a foreclosure order. And it's very important in my submission to separate out the issues of principle with the issues of practicality. And what they're doing is playing in a practicality against principle. Sorry, Justice. Do you
deny that it's a related party transaction?
We do, because we're not a shareholder.
Who's we?
Omnia was not a shareholder at the relevant time. And we've also, I should also agree that it's not just the value of the land that we're offering to pay, the 108 million. It's also that we are also agreeing to pay off a part of the debt, which brings the value to about 160 million. So the bottom line is that we don't accept any of this, Justice, but we also don't accept that you have sufficient evidence to evaluate that question. It's only come in at the final stage in reply. So we don't accept it. We don't accept what they say. We don't accept it's not market value. Don't accept it's a related party transaction. But more importantly, you don't have that information. And the reason you don't have that information is because of the approach that Emirates took right up until the final reply submissions.
You've said, can I just raise another point, Mr. Flynn? You've said a number of times that you're entitled to 6 months. Now, I just wonder if that is an accurate description of the authorities. The authorities seem to me to establish the proposition that it has been the usual practice of the courts of England at a time when foreclosure orders were granted more commonly than they are now. Yeah. But it was then the usual practice to follow the order nisi procedure. Yeah. But that's a bit different to saying that there is a legal entitlement to an order nisi. And one would have thought, if that's right, and so it is a question for the court to determine on the circumstances of each case, couldn't it be said that in a case in which you'd been in default in repayment of principal for almost 4 years and default in payment of interest for 3 years, that there would be little point in because you've had all that time to rationalise your affairs, make an orderly sale of the property and put your affairs in order and meet your responsibility to the bank, couldn't it be said that in those circumstances there would be good reason for departing from the usual practice of granting 6 months order nisi?
Right. Can I? There are quite a few issues in there. Let me just put it this way. So far as English law is concerned, it is, in my submission, a substantive rule that you get a last opportunity to make payment, and it's a 6 month period. That's in the standard form. It's in the authorities. The period is the 6 month period. Query, and that is whether you've been in default before or not. So in other words, you're always given that last opportunity. Now, in my submission, what ought to have happened here is Emirates ought to have made their application earlier, if they, in the light of that. But that's a separate matter. The next issue is, so we do say it's a rule, so far as England is concerned, that you get your last bite, a 6 month bite, come what may. If your lordship is saying to me, are we bound by English law? The answer is no. You could make your own determination. I accept that. Is it open to the court to give some different period? Then I would accept yes, but it would need to be a proper. What's said against me is, oh, you had 19 days, almost fortuitously, to pay off the debt. That plainly isn't sufficient. It would need to be a proper period. If you're against me and it was less than 6 months, it would need to be a proper period to effect the sale. Now, what the court does know is that, notwithstanding that a foreclosure order has been made and ownership transferred to Emirates, steps have nevertheless been taken to effect a sale, and you've seen the document, the sale document. Now, there are certain things that need to be done to give effect to that. In my submission, it's clear that we have made those efforts. It's not like my client sat on his hands and done nothing. They have taken steps. You've seen what they've done. They would need time to put that into effect. Does it have to be absolutely 6 months? Is the court bound by that period for this purpose? I would accept that the court could vary that period, but in my submission it would have to be a serious and substantial period to give my clients a proper opportunity to effect that document and get the necessary consents. And that I hope that answers your question, which is, so far as English law is concerned, it's a substantive rule. It's 6 months. You're not bound by English law. You should be guided, in my submission, by English law. It doesn't matter in my submission that there have been prior defaults. If the question is a proper opportunity to have a last bite at the cherry, we haven't done nothing. You have the material that you've seen. My client wants to sell the property on the terms that you've seen, and in my submission, they ought to be given that opportunity. And the consequence of that is that Emirates get repaid.
Yes, well, thank you, Mr. Flynn. I understand your position. Thank you.
Now, I was going to take you through my submissions, but I don't want to. I think I don't want to trouble the court unnecessarily. I'm going to take you through foreclosure and so on, and what the position is. And there's quite a lot, but I see where the court is coming from. I don't want to trot you through the authorities and so on if it's not going to be any assistance to you. So I'll be guided by the court. Clearly, I don't need to go into the facts. You've got those fully on board. But I was going to show you why foreclosure is an extreme and rare remedy and why it's an issue of principle, not of practicality. But I don't want to labour this with the court if it's not helpful.
Okay, why don't you just briefly go through them, and if we need expansion or we need some clarification, for record purposes, let's go through them, but don't take too much time.
Okay, I will do it as quickly as I can. And Justice Martin, you were also going to say something there as well.
Well, I was going to say, the procedural issues about not granting the adjournment, not telling Ms. Al-Jaber that she had the power to ask the court to give her permission to be heard.
No.
All of that really stands or falls on your fundamental proposition, does it? Because if your fundamental proposition is wrong, then all of that goes nowhere, because the only point that could have been made is we need 6 months. And if that point isn't good, so...
Yeah. I wasn't going to say any more about that. I think the only issue is...
Yes.
I'll go through it as quickly as I can. There's the Supreme Court reference, if you're not with me on the main point. That would arise in any event. So let me. So if I quickly run through what I was going to say, I think the court probably has the principles, but the third point I was going to make is foreclosure is an extreme and rare remedy. And it's now accepted in the reply submissions at paragraph 77 that the remedy of foreclosure has become very uncommon in English law. That's a very understated way of putting the proposition, but that's certainly accepted as very uncommon in English law. And it's an extreme remedy because it has the effect of transferring title and thus any equity of redemption to a lender. And in England, it was said to be rare nearly 30 years ago in 1993. And the Law Commission in England has actually recommended the abolition of foreclosure. So we submit that in this jurisdiction, that should be fully taken into account, and orders for foreclosure should be approached with some considerable caution. And there are some very well established and necessary requirements and safeguards before such an order can properly be made. And if the case against me is right, there aren't any safeguards or requirements in the DIFC. And we submit that will be out of line and against the direction of traffic in the rest of the common law world, apart, it seems, from Australia, on which heavy reliance is taken to justify the approach taken by the judge. And we submit. I expect
that's my fault, Mr.
It may well be, but in Australia there are also safeguards. So that's why we say it's not just these litigants in this case. It does require a principled approach. Fourth point is no order for foreclosure should have been made without joining any interested third parties. And we say that's a substantive rule. And that's the case regardless of whether there is positive evidence before the court as to whether or not there are interested third parties. And we say it would be a very rare case indeed that the court could be satisfied that there were no interested parties at all, at least without providing the opportunity for them to come before the court and protect their position, or having positive evidence, credible evidence, to say that there are no such interests. Now, this case is unusual because it went the other way. The judge had before him material suggesting that the Abu Dhabi Commercial Bank did have an interest in the property, but he nevertheless made the order absolute. Now, without hearing from ADCB, and contrary to the interest that the documents indicated were there. Now, we accept, obviously, now, as it transpired, that no mortgage was executed in favour of ADCB. And we say the judge took the wrong approach when he was confronted with a potential third-party interest. But in a way, that sort of misleads, because the point is that in any case, whether or not there is evidence, the court needs to take into account the interests of third parties. And unless there's positive, credible evidence that there are no such interests, it shouldn't just proceed to a foreclosure order, certainly not absolute. And so we say it's still relevant that there was evidence of third-party interest before the judge, because the judge.
Mr. Flynn, but that might be right in principle, but in order to succeed in an appeal on that ground alone, and I accept it's part and parcel of your argument about procedural irregularity, but in order to succeed on that ground alone, you'd have to show that it would have made a difference. And the only two parties with an interest in the property of which the judge was aware were DIFCI and ADCB. Both of them have now been made well aware of the proceedings, and neither of them want to participate. So if he had done as you say and given them notice entitled them to participate, it wouldn't have made any difference, would it?
We submit it would have made a difference, because I think what he would have done was to make the order nicer. Because even in those circumstances, the right approach, if the court considers that there is that it is right to make a foreclosure order at all, and that it's safe to do so, the way to do that is to make the order nicer. What is very
really, it feeds into your order nicer point.
Exactly, it absolutely does. I also should have said that the other point we have is the arbitration point, which is another one that is self-standing. So there are other points floating about. I appreciate that.
Well, just on that, the case against you on the arbitration point is, I think, twofold. First of all, the arbitration agreement is in the security documents, not the mortgage, and the bank was proceeding on the mortgage. And secondly, that even if the arbitration agreement did embrace the dispute under the mortgage, the remedy of foreclosure is a remedy which in the DIFC can only be granted by the court, and therefore even if the arbitration agreement had been drawn to the court's attention, it would not have resulted in a stay, because the relief being sought was not relief which could be obtained through the arbitration agreement. Now, what do you say to those propositions?
There's two points in relation to that. Firstly, we don't accept that the arbitration clause was so limited it didn't encompass the dispute in relation to the mortgage. So that, in other words, the arbitration clause bit on the dispute, and therefore, and if that is right, then
sorry.
Once that...
We missed a few of your last. I can't hear. I didn't hear your last few sentences. The audio went a bit haywire.
I'm sorry. Of course, I'm sorry, Chief Justice. Can you hear me now?
Yeah.
So there are two. Justice Martin has put his finger on what the points of principle are, and they are two.
Yeah, we've got that. Okay, go on.
The first point is the dispute governed by the arbitration agreement? And in our case, we submit it is. So in other words, the dispute has to be resolved by an arbitration procedure. Okay, so that is the first point. Then the second point is, yes, the order for foreclosure is an order that can only be granted by the court, but the court can't make a foreclosure order until the dispute is resolved in arbitration. So the answer to those 2 points is effectively the same, is the arbitration clause bites on the dispute, and the dispute is one that has to be resolved by arbitration. And so those points of principle meet that issue. It's no answer to say that only the court has the power to foreclose. I accept that, but the point is the court can't act in the absence of the dispute being resolved in the arbitration. So again, it's still a live issue. And that's the answer. That's the answer to that point. Now, yes. So just in terms of what is now said against me, Emirates in their submissions on this appeal make much of the proposition that in the event, because of a set of restructuring arrangements entered in 2014, ENDB are obliged to pay any surplus to ADCB, and that would protect all parties' positions. Now, as I say, that is not something we accept, because particularly also we don't accept that the foreclosure order itself, it may have an impact. It may be that the restructuring agreements don't operate in the way described. Justice Martin said, I think, what you've done by the undertakings is put yourself in the position of a mortgagee in possession. Yes, and in a sense, that's what they're trying to do by giving these late undertakings. But by the foreclosure order, it's not at all clear that there's any obligation under the foreclosure order to get the best price on a sale, because you're selling as owner, not selling as a mortgagee in possession. And so there's a lot of arguments in relation to that. I mean, I can't. Yeah, I'm sorry.
Well, the most significant distinction, which I think does identify a real difference between the situation we're now in and mortgagee sale, is that if there'd been a mortgagee sale without the intervention of the court, then the mortgagee's obligation would have been to pay itself out first, and then remit the balance to the mortgagor, and the mortgagee would have had no right to retain any funds over and above the amount of its debt. Whereas under the undertakings that are proposed, as a result of the foreclosure, the mortgagee proposes to take the money due under the debt, but also to then pay other secured creditors rather than remit the money to the mortgagor. So that is a material difference between the two scenarios, isn't it?
I agree. And I can't say that's the only one. And the difficulty here is I'm very cautious, if I take a step back from this, that our case is this is an issue of principle. What is said against me is they say, oh, well, if we give these undertakings, it makes it fair for everybody. Now, the first point is this is an issue of principle. The wrongful making of a foreclosure order can't be remedied by the argument that the parties are no worse off by the order because of their contractual arrangements combined with some undertakings. And so in my submission, it's a very, very clear red flag that these undertakings are necessary. And I think you also said, oh, what about an obligation to sale? And then it's, oh, well, we could give that undertaking. The point is, this is gap filling. It's very dangerous and it's unprincipled. And the reason it's dangerous and unprincipled is because the issue for this court is one of principle. And the answer in my submission is clear as a matter of principle. And it's no answer, either in principle or frankly in practice, to try and make it work by piecing together undertakings and other obligations that don't work within the structure of the law. In my submission, the law is clear and it's there. It has established principles. It has established consequences. The approach that EMBD is asking the court to do are actually unfair because they don't give a proper opportunity to ventilate these issues of fairness, market value, and all those things that are said against me. And it also doesn't fit this case into the established structure. And that, in my submission, is very dangerous. And so we submit it's not right. The correct remedy is one of principle based on an error of law, and it lies as an appeal to this court. Now, on that basis, if your lordships are with us on this order nisi, in our submission, we succeed. And the proper order is one of two things. One is either you set aside the foreclosure order completely, but I accept that that affects the bank's security, and the court may not be willing to do that. But there is an obvious solution, which is you date back the order nisi to the date of first instance, with 6 months in the future to make the payment. And I should say, what is said in the reply submissions, ENBD classify our central complaint as being a complaint about the equity remaining in the property, or whether there is an unjustifiable windfall, or even our complaint is about protecting the interests of ADCB. But it comes back to this. The fundamental point is principle, that an order for foreclosure shouldn't have been made by the judge in the circumstances that existed and in the form that he did. Now, windfall and prejudice to third parties may well follow from taking the wrong approach, but the point is one of principle. And we say if our grounds are made out, then the relief we seek should follow. These other complaints, as I say, they're unprincipled, and the court simply can't evaluate them, just not in a position to do that. And as particularly as we don't accept them, we don't accept, as I say, related party, market whether it's not at market value, and so on. And then, if we are with us on that, I agree. The rest of the grounds, discretion by the. I'm sorry, Chief Justice.
But I thought those are terms of the agreement. Is that correct? Mr. Montague was mentioning there were term of agreements just now. If you cannot sell to related party, I don't know why you have those terms, but it seems they are terms of your agreement.
Yeah, yes, but we don't say what is a related party. Our position is very straightforward. So far as we are concerned, we agree we've got to get the consent, I think, of DIFC Investments. We have to get their consent under the agreements. Apart from that, there is no reason, in principle, why the sale can't go ahead. That's our position. What's said against us is, oh, there are lots of reasons why not, and also it's unfair. And we don't accept any of that. And in my submission, the court can't evaluate any of that. It's just not possible to evaluate that. That would be a matter that would have to be properly ventilated at first instance, ironically, as I say, in the way in which we were saying. We were saying that this is what needs to be done at first instance. That wasn't what was done. And now, right at the last set of submissions against us, is that the court should take into account the interests of others, such as the Al Jabab group. You're only told one side of the story in relation to that. We would want
Mr. Flynn.
Yeah.
Sorry. Your proposition, as I understand it, is that if there is a right to restrain the sale that has been identified to Omniat, then that's got nothing to do with the relief which you seek, which is 6 months within which to make a sale. Yeah. And if there is a right to restrain that sale, then that sale will be restrained. And unless you can find another sale within 6 months, then in 6 months the foreclosure will become absolute. That's and so that you say the question of whether or not that sale should proceed is a question for another day.
I absolutely, that's exactly what I say. If they want to apply at first instance for an injunction restraining the sale on the grounds that they've identified, then so let them do that. It would be an extraordinary thing to do, and we'll have to meet that. That's their case, but it's not the issue on this appeal. You're simply not in a position to evaluate that. Our case is irrelevant. They say it is relevant because it's fair. That's essentially what they say, taking into account everybody's interests. But I absolutely agree that the obvious solution to this appeal in my submission is to date back the order nisi, give 6 months to pay. If for whatever reason a sale isn't effected in 6 months from now, then Emirates get the order absolute and they get title. If the sale is made, they get repaid on the basis of our case. And then apart from that, these are matters for another day if they are indeed going to be taken at all. Now I'm just looking at my notes and what more I want to say. I was going to take you to the letter of sale, but I'm not. I see you've obviously read that with some care. I'm not sure it's really helpful to you to go back to that. It's there. If it succeeds, if we get DIFC investments consent, Emirates gets repaid. If they restrain it or take other points in due course, well, that's a matter for them. As we say, the only interest, legitimate interest, we say, in relation to EMBD for this appeal is their interest to be repaid the debt. And that's what is the focus in a foreclosure action, which is their interest to be repaid the debt. The other security interests, these are other issues and not relevant. And Omniat's offer involves a discharge of that debt, Emirates EMBD's debt, out of the sale proceeds. So effectively, EMBD are secured if the sale goes ahead. That's. I wonder
though, Mr. Flynn, because curiously, and I've said last time, I think I've never seen a mortgage that expires on a fixed date. But if the order nisi had been granted in the middle of June, that doesn't stop the mortgage expiring, does it?
No,
so
it doesn't.
Expires. So if the order nisi, if your client goes out and sells at less than, once the mortgage is lapsed, the secured creditor has no capacity to restrain any sale at all, does it?
It does in my submission, and the reason for that is this: provided that order nisi is made during the pendency of the mortgage, the court is in control, and the mortgage is effectively replaced by the order nisi, so that the court can take control of what's going to happen. So, for example, if by the end of the 6 months period the sale takes place, the security can be discharged. If not, then they get the title is transferred to EMBD, so it doesn't arise as an issue.
But how would that work in practice? So if we made the order, we give you the relief you seek, we make the order nisi, backdate it to June, but give it another 6 months of currency. The mortgage is lapsed. How would you actually effect a sale? And would you have to seek the court's consent to effect a sale? How would that work in practice?
I don't think we would need the court's consent. We would simply discharge the debt to EMBD. So we'd effect the sale.
But what if you didn't? What if you didn't? The mortgage is lapsed. You don't have to. The mortgagee couldn't restrain the sale from proceeding. You could, if the order is revoked, the order absolute is revoked, and you get an order nisi, there would be a renotation of the register. You'd be shown as the secured, as the registered title holder. The mortgage would have lapsed, so you'd have full power to do whatever you like with the property, wouldn't you?
No. So the way it would work is that there are two possibilities. Either a sale is effected within the 6 month period or whatever period the court considers appropriate. If a sale is effected, what happens is that obviously takes place. The debt is discharged. There's no issue in those circumstances. My clients have sold the property. EMBD are paid out. The other alternative is there is no sale. If there's no sale by the date, Oh, sorry.
There are lots of other alternatives. There could be a sale at less than the value of the debt, or there could be a sale without you accounting to the bank for the proceeds. Because ordinarily, when the bank is there as mortgagee, the bank turns up to settlement, and you have to get a discharge of the mortgage in order to make title to the purchaser. But if the mortgage is lapsed, none of that applies. So you could just go out and sell it. You could sell it to the man next door for 3 dirham.
Well,
and the bank is left lamenting, isn't it?
I don't accept that. I mean, what would happen is, if that were the case, then there could be an application to court. I mean, if there is this in halfway house at the moment, there'll be the.
What's the bank's security during the period of the order nisi? Isn't that the problem in this case?
Well, no, because the security in my submission comes from the order nisi itself. It's that order which is, if the debt isn't repaid, then the EMBD will get title to the land itself. There's no need for security. They actually have the title.
So the order nisi would say unless. So the order would be unless. Well, what would happen on the register? Would the order nisi be noted on the register as a charge? How would it work?
I can't see any reason that would preclude that, but I'm not sure whether it would be actually necessary to do that. But yes, I mean, that maybe the EMBD would protect their interests.
If your client's restored to the register, which you say it must be in order to give it the opportunity to sell, what's to stop it doing what it likes? And then, of course, under the torrent system of title, once a transfer is registered, executed by the transferor, who's the registered proprietor, then the incoming purchaser gets good title. So what would stop that from happening?
The order absolute would be on the condition that the debt is repaid, the mortgage debt is repaid. So if you're back on the register, what happens to how does the order absolute work? By the time the order absolute comes to be made, there's another registered proprietor whose interest is indefeasible under the torrent system. How does all that work? I just don't understand that. Well, then the order nisi would be registered. I mean, the idea, the third party couldn't get title, because what would happen is that it would only be if EMBD are repaid their debt, that title could pass under the pursuant to the order nisi. It's only if they get repaid.
But if your client's back on the register, which you say they must be, then the court order would mean nothing. So that your client is the registered proprietor. It executes a transfer in favour of a bona fide purchaser for value without notice. The bona fide purchaser for value without notice produces the transfer, which is registered, and then title passes. The bank's left lamenting. The court is left with nothing to do, because it can't execute an order absolute against a bona fide purchaser for value without notice, who's now the registered proprietor.
I'll just tell you, Your Lordship, this, that we are, I'm told, happy to provide any undertakings that you think are necessary to protect the position. I'm not sure.
But filling gaps, but Mr. Flynn, I was just told that filling gaps with undertakings is dangerous practice.
No, it's true, but I do believe that. But I don't accept there is a problem here, because it seems to me that it's the court that's in control. It's the court that makes the order nisi. It's the order nisi that has replaced the security. The idea that there would be a loss of security without EMBD being repaid, in my submission, is fanciful. If there were any possibility of that, and there were any gaps in the DIFC law, EMBD would go to court and get an order. I mean, I have no doubt about that whatsoever. I don't accept that it doesn't work, that there is an issue here, provided potential purchasers will see that there is an order nisi, and they'll understand the terms of that order, and obviously everything will have to be done on the basis of that order.
But it seems to be, Mr. Flynn, this is a very important point, because unless you can persuade us that the bank's security was maintained during the period of the order nisi, then it's very hard to see how the judge was wrong to not make the order nisi. So in other words, the judge was motivated by what he did, by concern at the bank's loss of security on the 30th of June 2020. So if the order nisi didn't protect the bank's position as secured creditor, then it's hard to see that English practice would have in effect, required the judge to not give effect to the bank's security.
Can
I think just putting your hat, saying, well, of course that must be right. The bank must have retained its interest. Doesn't for me at least doesn't quite cut it.
Can I take it in stages? First stage is this: we also have offered to extend the mortgage. So if that's agreeable, that sort of circumvents the issue at all. There, we've done that in the past. Perfectly happy to do that if that's the solution. The second point is this: that I think what your Honour is saying is what happens in relation to a torrens system if there's an order nisi, and the answer to me is that the order nisi should be put on the register, and the court can direct that the register should record the order. I mean, we're in a unique situation here because I think this is the first time this has arisen, but that would be the obvious answer, which is that interest, that security interest, goes on the register. And then in those
the order nisi isn't a security interest. The order nisi is simply an order of the court that unless something happens within a specified period, something else will happen. Now, if in the meantime there is a dealing on with the land, the order of the court becomes incapable of performance. So I'm just not seeing how it works. I mean, I would want, frankly, I think we need to be taken through the DIFC property law to be shown how all that works, because otherwise it's hard to see the judge got it wrong.
Well,
Judge Martin, we should go through because the way I read through the Dubai law, land law, is very, very, very brief. Very only major principles are stated in the act. You know, this detail I think could be by way of common law. I don't know. So because the law is very new,
yes,
there's not much interpretation that has been given to the provisions. So can you just take us through the relevant provision, Mr. Fleet?
Of course I will. I'll tell you now that I don't think you'll get an answer, but I will definitely take you to the law. The source of the power to order foreclosure is Article 73 of the Real Property Law. That is, if we can call that up, that is in Bundle 3, Tab 1, Document 4 at page 10. See if we can get that up.
Can you put that on the screen? Is that possible?
Yes. I'm just trying to do that.
Bundle, do you know, Mr. Flynn?
Sorry, the reference is Bundle 3, Tab 1, Document 4, page 10. In fact, somebody's doing that for me.
Well, that reference doesn't correspond to the e-bundle that I'm working from, I'm afraid.
Oh, okay. It's Article 70. Look, I'll ask somebody if they could call it up. I'll just tell you what it says, because it's very simple, and then we'll try and get it up on screen. Article 71 says, on application by a registered mortgagee, the court may make an order for foreclosure. And that is the court's power to order foreclosure. No more is said in the text about when such an order can be made. No, we haven't got. Sorry, I think there's a glitch in.
Can I help with references?
Yes.
So there's a hearing bundle and an authorities bundle. If you've got the authorities bundle and go to section 1 of that, document 5, you've got a copy of the whole of the law. If you then go down to page 4, little v, you get to Article 63, which I'm sure my own friend's going to show you as well. But then on page 4x is Article 70.
Thank you.
Yeah.
Good. So, yes, thank you. I've got it now. Yeah. Yes, I have it.
Sorry, I'm going to try and call it up as well.
Yes, please. I cannot get it on my iPad. I mean, it goes off and on. I have to keep on the registering, logging. You have to keep on logging back because.
But as you'll be aware, Mr. Flynn, I'm not so much interested in foreclosure as the protection of the interest of the bank once its mortgage lapses. And if that's all the law says about foreclosure, it leaves a lot unstated, doesn't it?
Yeah, well, it does. I'll tell you what the other provisions say. If Section 72 provides, if the court makes an order for foreclosure, the registrar shall notate the order on the folio to which it relates if requested by a party to the proceedings or directed by the court. And then 70 subsection 3 provides, on notation of the order, the mortgagor's real property interest in the lot vests in the mortgagee, free from all liability under mortgages or other real property interests registered after the mortgage, except for leases and other real property rights that bind the mortgagee under this law or contractually with the respective parties. In other words, that's the consequence of foreclosure, which is that all subsequent encumbrances are foreclosed.
All right. Well, that consequence wouldn't take place until the order was made absolute. So yes. The order nisi would be an indication by the court that unless something happens within a specified period, then an order of that kind will be made. So in the meantime, yes. Then there is no alteration. The order nisi doesn't alter any of the property interests. So then if the mortgage lapses, doesn't it? And then the bank loses its security and the registered proprietor can deal with the land as it thinks fit.
What are the circumstances in which the mortgage, you mentioned just now, this is very unusual term. You know, normally you doesn't lapse until you settle the debt. Then this charge.
But I don't accept the proposition that the court can't make an effective order nisi, which this would be the consequence of the submission, which is it wouldn't be possible for the court to make an effective order nisi. I don't.
Well, can you tell us what the order would say?
Well, the order would say unless the debt is discharged by a certain date, then title is transferred to EMBD. That would be. And if by that date the registered proprietor has sold the land to somebody else, what happens to the order? Nothing. Can't be enforced because no order for foreclosure has been made.
But it cannot be transferred without the consent of the mortgagee, isn't it? If it is registered on the register.
But Chief Justice, there is no mortgagee after the 30th of June. That's the problem. Once the mortgage lapses, the mortgagee loses its interest in the title. So the title can be transferred by the registered proprietor without reference to anybody. Isn't that the problem?
Well, if that is the problem, then surely and if that is a hole in the process, surely the answer is we undertake.
Just directs the registrar.
I think the issue, Justice Martin, that you're identifying is what happens if my clients sell the property before the deadline. Is that?
Yes.
But if they sell the property before the deadline, provided they discharge the debt to Emirates.
Yes, but what if they don't?
The caveat can stop them.
What could stop them?
Caveat.
Well, it would make.
There's no caveat about. There's no caveatable. I can hear you. The not so sotto voce. There's no caveatable interest because the proprietary interest of the mortgagee lapsed on the 30th of June.
Except that it's replaced by the order nisi. Now, in the ordinary course,
the order nisi doesn't grant a property interest. That's the problem I'm having, The order nisi is nothing more than an indication by the court that unless something happens at a certain time, an order will be made. I'm struggling to see how an order nisi can create or extend any proprietary interest in the mortgagee. And unless you can persuade me of that, I'm having trouble seeing how the judge was wrong by not granting an order nisi.
But that would mean you could never, in these, you couldn't make an order nisi if that is right.
Yes, I mean, exactly.
So I think isn't the answer.
So the problem is that perhaps translating English practice to Torham's system title of land doesn't work.
Well, it's not the only. I suppose the answer we could. I mean, it would be you could deal with it by giving an undertaking that you won't sell, say for unless you discharge the debt due to Emirates. So there'll be an undertaking to the court not to do that.
But that's much less protection to a secured creditor than having a registered interest on the title. Because an undertaking to the court doesn't restrain a sale. If you've got a registered interest on the title, nobody can deal with that title without dealing with you. An undertaking to the court doesn't achieve that. You sell the land, take the money, and get on an aeroplane, you're gone. Whereas if the mortgagee's still got their interest there, you can't do that because you've got to deal with the mortgagee to get clear title.
We see. I suppose what that gives rise to, I don't, is that if that is the case, then the bank has to apply in enough time for more than 6 months. It has to get the application more than 6 months before the end of the mortgage.
So then the proposition becomes that the penalty, that the judge was wrong, not by not ordering an order nisi, but by refusing to grant the bank any relief at all, because it should have brought its application 6 months earlier. Is that the proposition now?
Well, if we're in this territory, that's the difficulty I have. I don't accept for one moment that if you're in a Torrens system, that fundamentally changes the issue of principle of approach. I don't accept that.
But you can say you don't accept it, but I don't understand the reasoning behind that lack of acceptance, Mr. Flynn, because I don't understand why the order nisi would create any protection for the bank's interest after the 30th of June. And unless you can bring me to that understanding, I have terrible difficulty in seeing how, in your case, the judge was right to not order sale, but somehow wrong to order foreclosure when he should have made an order nisi, because the consequence is the same. Whatever rights the bank had lapsed on the 30th of June. So the judge was then in the dilemma of, does he do nothing, in which case the bank's secured interest lapses, or does he make foreclosure? And you don't run a case on the basis that he was wrong to make foreclosure. You run a case on the basis that he was wrong not to grant an order nisi. But if the order nisi is in effect the same as not making any order, then it's hard to see how that proposition can be right, unless you say it was wrong for him to make any order at all. I'm putting that poorly, but I think you get the drift of what I'm saying.
I do get the drift of it. I think the answer is this, that it's once the order nisi is made, it is that order which effectively is the operative instrument. So although what that, and the court is in control of that instrument. So that.
But I don't understand. What do you mean by operative instrument? It's an order of the court that unless something happens within 6 months, another order of the court will be made. It's nothing more than an order of the court. It's not the grant of a security. It's not the extension of a proprietary interest. It is an order of the court that unless something else happens, then in 6 months something else will happen. So characterising it as an operative instrument doesn't really help me. What I want to know is, what is the status what is the status of the title when such an order is made and the mortgage lapses by the effluxion of time?
Well, I said even if it's not an order for security, if the order NISA is put on the register, then
all right. Well, where under the DRC property law can you register an order NISA for foreclosure? Take me to that.
Well, there isn't anything, because the law is very broadly stated. It doesn't deal with these.
If there's no power to register an order NISA for foreclosure, the registrar won't register it, will he?
Well, he would register an interest if directed by the court to do so.
That's my point. The register under Torrens System land, the register is a register of proprietary interests. The order NISA doesn't create a proprietary interest. So the registrar would say, I run a register that records proprietary interests. Your client is the potential beneficiary of a court order if certain things happen in 6 months' time. That doesn't give it a proprietary interest. Therefore, I'm not going to register it. Isn't that what the registrar would do?
Or what other security could you provide, Mr. Flynn?
Well,
any other security?
What we can do is do what the other side have done, which is provide an undertaking that we won't. I mean, what if we take a step back? What is sought to be achieved here is to allow a period for my client to sell the property. That is what we seek to achieve. Now, in my submission, that is perfectly capable of being done in the DIFC whilst giving protection to all parties. Now,
well, I hear you say that, but how? I don't understand that, because an undertaking is not anything equivalent to the register of an interest on the title. An undertaking to the court is a very, very different thing. As I said to you before, you can give people can and do undertakings to the court that are not honoured. So if your client was mischievously inclined, gives the undertaking to the court, sells the land for however many million dirham, and then gets on an aeroplane and flies away. He's breached the undertaking of the court, but there's nothing the bank can do to stop that, because he's the registered proprietor and the bank has no interest in the property.
Okay, well then the other way of putting it is this: that the order is kept as the order absolute, but it is subject to the ability of my clients to make a sale within the 6 months, and that would be a property interest. In other words, you make it absolute, but you're not denied this opportunity, which is a substantive opportunity of law. So you're not denied your 6 months. Then
how you proceed the sale if you didn't have a title? That's another problem again.
Well, then we have to persuade the buyers of that. I understand that is a problem, but I'm trying to find a solution, and I think the solution would therefore be, if Justice Martin is right, what would happen is the order is made absolute to be registered on the register, but it is subject to a caveat, and the caveat is the 6 month period to allow my clients to make a sale. So in other words, what would happen is, because just taking a step back, Justice Martin, it can't be right in my submission in principle that if you accept my submissions that my clients ought to have a period, a last bite at the cherry, to make the payment and discharge the debt, which in my submission is absolutely clear. It's the reason why foreclosure is so rare. If you accept that, then it's simply a question of how one approaches that under DIFC law. And in my submission, if that is right and only a property interest could be registered, that would be the order absolute, which is a property interest, but it would be a caveat, and the caveat would be a 6 month period in which to effect a sale that fully pays off the debt of EMBD. Now, in those circumstances, that does everything, because what it does is it meets the point of substance. It goes on the register, it's a property interest. It meets the fact that if I'm right, the application should have been made earlier, because actually this is a problem in my submission of EMBD's own making by not allowing the mortgage to expire during this period. It also means that they're protected on their security, and it also means that my clients have the opportunity to make the sale that they should do. Now, that would be the way to do it. Now, I accept that that's changed it, but it's meeting, I hope, Justice Martin's point, which is...
Well, it'd have to be an order, wouldn't it? It'd be an order for foreclosure on the basis that the party receiving the interest, that is in this case the bank, would be restrained from dealing with the land for a period of 6 months, during which time the mortgagor would have liberty to apply to set aside the order for foreclosure in the event that it could satisfy the court that the bank's debt was to be paid.
Yes. So in other words,
the
practical solution would be this. There's a period of 6 months is the normal period. So let's use that for argument's sake. A period of 6 months in which my clients can make the sale. If they make a sale which pays off EMBD, discharges the debt, then the foreclosure order is made subject to that caveat, and the sale is permitted. And when
the effect of the order would be to create an ongoing interest in the mortgagor that could be protected by a caveat. So the mortgagor would not be the registered proprietor, but would be a caveator giving the world notice of its right to apply to the court within 6 months to be restored to the register.
Yes, and that way it would. I mean,
Judge Martin, if the court makes that order to say that you're not to, that order can be recorded and registered, isn't it?
Well, no, I don't think so, Chief Justice. I think the register is a register of proprietary interests. But I say all that. I mean, I haven't studied the DIFC property law in any detail at all, and I'm a bit concerned that this has all taken you on the hop a bit, Mr. Flynn. No, I'm just wondering if you want the opportunity to put forward this further submissions.
Mr. Flynn quite rightly say, it's like a caveat, you know. So
well, caveat is it's a warning, but it doesn't create a proprietary interest. It's simply a warning to others, and the caveat would then have to be relieved before there could be a dealing. But I think, again, certainly, assuming the torrent system in the DIFC is similar to the torrent systems with which I'm familiar, then the order of the kind proposed by Mr. Flynn would give rise to a caveatable interest, I think. But I say that not having checked the DIFC property law, and I think my concern is that we're all stumbling about a bit in the dark here, and I just wonder if we need a bit more light. But perhaps Mr. Montague-Smith can provide that. But
I think I'm dealing with Justice Martin. I'm dealing with your issue of principle, and I think the point you fairly make is it's got to be an interest in rem to go on the register. An order absolute would be. I mean, I don't think there's any question about that. But there's nothing. I mean, Mr. Montague-Smith may be able to take you something, but I don't believe there's anything in the law that would prevent a caveat being given. So in other words, it satisfies your Justice Martin, your point, which is it's got to be an in rem interest. This would be an in rem interest. There is no reason in principle why you can't caveat an in rem interest. The court is in control of that. The court
is interested in that caveat? Who is the interested party in the caveat?
So the mortgagor.
To make sure that the property is not sold off or transferred to another third party. Who?
So what would happen is this: the order would be made, and the order it would be an order absolute. In other words, EMBD retains the title, but that title is subject to a sale being effected within 6 months, which discharges their debt.
It wouldn't have to be. It'd have to be an order absolute, but on condition that the bank not transfer or otherwise deal with the property for a period of 6 months, during which time the mortgagor would have the entitlement to apply to the court to set aside the order for foreclosure. And that right to apply and the prohibition by the court upon dealing with the property for a period of 6 months during which that right existed would give rise to a caveatable interest, which the mortgagor could then protect by caveat, and then any person wishing to acquire the land from the bank would have to deal with the caveator, give notice to the caveator, in which case the caveator, the mortgagor, could come to the court and say the bank are trying to sell the land contrary to the condition which you have imposed, restrain the bank from doing so. That's how it'd work, isn't it?
Exactly. And I mean, in a sense, it's sort of the mirror of the undertakings that have been offered. I mean, if you're with me that we should have 6 months, that is the practical solution. What I balk at is the idea that the court is effectively powerless in these circumstances. And as I say, that would be the practical way of doing it if the bank doesn't make its application for foreclosure within such period as allows for the 6 months to expire. So actually, it balances the interests of both parties if you do it that way, and then it doesn't offend against anything in the law. The court has the ability to do that. As I say, I'm not aware of anything in the DIFC law which would prevent that being done. The laws are very broadly stated, but I do accept it's an in rem interest, and this would meet that point. Can I just remind you of what the judge said about it? Let me just see if I can call it up, which is in his order of the 15th of June, which is bundle 4, tab 1, page 10. Paragraph 35. Do you have that?
Again, sorry?
Bundle 4, tab 1, document 1, page 10.
I have it.
Do you see? I hope the court has that.
Yes.
And you'll see at 35, the judge sets out the equitable principles which realign. If the mortgaged land is worth more than the amount of the debt it secures, by foreclosure, the mortgagee will gain a windfall at the expense of the mortgagor. Since the mortgagee will take the land free from subsequent security interests, again, if the land is worth more than the amount of debt it secures, the holder of a subsequent security interest will be prejudiced. It will lose its security. Hence, in a foreclosure suit in equity, it was necessary for the holder of a subsequent security interest to be joined in the proceedings. At least it had an interest in whether the mortgagee was entitled to foreclosure. A foreclosure order nisi was made, directing the taking of any necessary accounts and giving to the mortgagor time to pay the money due, and the holder of any subsequent security interest an opportunity to redeem the prime mortgage and so preserve its security. If there was neither payment nor redeeming up of foreclosure, and then over to page 11, a foreclosure order absolute followed, but the order was not necessarily final. Equity would open the foreclosure in some circumstances. And the judge says, and I have to say, I think he's right, unfortunately the real property law is silent on these matters. He says textually Article 70 provides the court may make an order for foreclosure, and that the order shall be notated by the register if it is made. So again, none of that indicates that the solution I've suggested is not open to the court. And then he says at line 6 of paragraph 37, on ordinary principles, joinder of any holder of a subsequent security interest is necessary as someone who will be affected by an order for foreclosure. And we say that's one of the grounds of our appeal. And then if you look at paragraph 37 on page 11 at line 8, there remains the need to consider any windfall and any prejudicial effect of foreclosure upon subsequent security holders, and in giving the court a jurisdiction equivalent to that of an equity court, the law cannot sensibly taken to have put those established considerations aside. And then that's obviously a reference to the origin of the jurisdiction to grant foreclosure. Now, I think in my submission, what's important here is that we don't lose sight of these fundamental principles of foreclosure being an extreme remedy, not easily granted, very uncommon under English law. The judge then goes on to say at paragraph 38, in my view, on an application for foreclosure under Article 70, it's open to the court to mould the grant of the order, having regard to such considerations. Now, I would suggest that's what we're asking the court to do, which is mould.
But if you go on,
Yeah.
If you go on in paragraph 38, he refers to sometimes that you can give respect to mortgagor's equity, and he says that may be by giving time to repay or sell. In some circumstances, no time at all may be warranted, or the opportunity to redeem up, or by imposing conditions on the order, or requiring undertaking.
Exactly. I was about.
Now, what do you say to the proposition that there may be some circumstances in which no time at all may be warranted? You say that by adoption of English practice, in virtually all circumstances, there should be 6 months.
Yes, I would suggest absolutely that. If you're against me on that, I mean that in my submission is it's substantive English law, that you give a last bite at the cherry. Under English law, it's 6 months, and that the parties rightfully expect that as a price of the extreme remedy of foreclosure. And that in my submission is, if you're against me on that, I mean, there's not really much I can say. No. In my submission, it is a fundamental right that you should have that last bite of the cherry. I appreciate 6 months is standard English practice. You're not bound by that. It could be, but it does, in my submission, have to be a proper opportunity to discharge the debt. So a proper, not 19 days, as is said against me. That was fine. That was enough. It isn't. It's got to be, and so in my submission, that has got to be granted as a matter of principle, and it needs to be sufficient time to make a sale. And 6 months, if you don't accept it as a substantive rule, it does guide the court as to what the sort of timescale you're looking at in a case of this kind. And so what I don't accept, what Justice Giles said, is no time is given. I don't accept that at all. That would be, in my submission, contrary to principle, that you don't give any time at all. So, and once you're into that territory, the only issue is how the court gives effect to that and what the time on the basis of the facts are. In my submission, it's still 6 months in this case, and the way to do it in a torrent system is if it can't be done any other way, is to make the order absolute with the caveat, with the necessary conditions. Now that would, in my submission, that would meet all points of principle. It would take account of the fact that EMBD didn't apply until a time when there would be an expiry of the mortgage. It takes that into account because it doesn't lose their interest. It takes account of the principle that you get some time to discharge the debt, and it takes account of the fact that this is a torrent system. It's no solution in my submission to say, well, you simply can't do this, you can't make any order, you can't do anything, because that would, in my submission, that would be very prejudicial, not just in this case, but to other litigants too. So in my submission, the solution is to do it in the way that I've suggested, which is an order absolute with relevant caveats to give effect to the underlying principle. Otherwise, the underlying principle it doesn't apply in the DIFC, and I don't accept that would be right. So we agree that the judge was rightly recognised that the court's jurisdiction to grant foreclosure under Article 70 is moulded by underlying considerations drawn from English law real property principles, which provides a just recognition of both the mortgagor's interest, which is their equity in the property, and third-party interests as well. So this solution takes account of all of those interests. And we don't, when the judge, I think that it's slightly dismissive when the judge talks about, Justice Giles talks about entrenched procedures of English law and practice. These are not procedural matters that we're dealing with here. It's not the process that is important as much as the substantive rules and the substantive principles, which is that there should be a last bite at the cherry. And we submit they're mandatory under English law, and they're an indispensable safeguard for the interests of the mortgagor and indeed interested third parties. In my submission, nothing in the DIFC law, the DIFC law is very shortly stated, is very broad. It's rather like, I don't know, the equivalent of what we would say Section 37 of the Supreme Court Act, which gives rise to the right to grant injunctions. There's a broad power. It's for this court to determine how that power is applied. Nothing in the law in my submission precludes what I've suggested as an answer. I should just say one point, which is that the judge also suggested that the Torrens system is different from English law, and there are undoubted differences. I'm not suggesting there are no differences, but he says since there's no equity of redemption where there is a charge, and I think EMBD seem to take a similar point, that they say it's not obvious how an equity of redemption could arise when mortgage operates as a charge. But our submission is the fact that the mortgage operates as a charge rather than a transfer of title with an equity of redemption doesn't alter the basic principles relating to foreclosure. In both a Torrens and a non-Torrens system, the mortgage is intended to stand as security for the lender's debt. And so any order transferring the property absolutely, foreclosing the interest of the mortgagor and third parties in the surplus, is in our submission a draconian order. If anything, Article 58.1 is clearer that under that rule, the mortgage is intended to stand as only as security. And secondly, in both systems, the effect of a foreclosure order is to extinguish the interest of the mortgagor and any interested third party. And under English law, that's called the equity of redemption in the case of a mortgagor, and an interest in the equity of redemption in the case of a third party security holder. And we say that interest is, if anything, enhanced in DIFC law because the mortgagor's interest is titled to the land subject to the mortgage rather than an equity of redemption. And so the principles governing the availability of foreclosure, such as the need to join third parties and make an order, which caveated order, must apply with equal force where a mortgage takes place by way of charge. In other words, the mere fact that it's a Torrens system rather than the English system doesn't affect the underlying principles of having a last bite at the cherry to make the payment before title is finally transferred. Because foreclosure has the same effect of extinguishing the mortgagors and any third party interests. And we say that it must therefore be subject to the same limitations. And that is consistent or possibly even more supported by the language in Article 58.2. That there it said that the mortgagor is taken to have an equity of redemption under the principles of English common law and equity. And we say that must mean that the principles of equity governing the right of redemption include the principles governing foreclosure, which extinguish that right, and that applies equally when a mortgage takes effect as a charge. So I think the short point is, so far as we are concerned, the suggestion which I gratefully adopt from Justice Martin, the solution is, in order to give effect to the underlying principles, is an order absolute but caveated in an appropriate way that protects the security interest and it gives the right to make have the final 6 months.
Well, the order absolute's already been made. So
it would be granted.
So
yes.
it would be allowing the appeal and imposing conditions.
Yes. Upon
the order absolute.
Exactly. That would be right.
Well, I think, speaking for myself, I think this is all, emerged ad hoc in the course of debate. I think it would be fair to the bank if the terms of the order that you seek were enunciated with some clarity, and perhaps that you might need a day or two to do that, and then just speaking entirely for myself, I think that would be fair, and then perhaps give the bank an opportunity to respond in writing as well.
I understand.
Because this is a significantly different turn of events to that foreshadowed.
Yeah, but let's hear what Mr. Montesquieu Smith has to say. I hope you don't depart too much from what Mr. Flynn has submitted, or the exchange of discussion or ideas coming up from us and Mr. Flynn towards coming to a conclusion, like a mutually agreed conclusion instead of going too much against it.
Yes, thank you very much. I don't know whether Mr. Flynn's finished his submissions. Would you like me to respond now, or?
Hey, Mr. Flynn, I thought that was the conclusion.
Well, we've got Mr. Taylor to deal with, haven't we?
Yes, you have. Yeah, you have. And can I say, I totally accept what Justice Martin has said about the debate. All I would say is that the substance is the same. It's really about how this is achieved. So it's the form. And I accept, of course, that we ought to put down the form of the order. But it's still the same. The points are essentially the same. The only it's just Mr. Taylor on the issue of the reference to the Union Supreme Court.
Mr. Taylor wants to address us. Yes, Mr. Taylor.
Chief Justice, Your Honour, Your Excellency, on one footing, I can be extremely brief. Whilst the court does not have the luxury to ignore the law in this respect, what it comes down to is that if the court is to reject a plea for the matter to be referred by my client to the Union Supreme Court, it must do so on the basis of a grounded judgment. Now, a very short and cogent reason for declining a reference to the Union Supreme Court would be that the appeal succeeding has rendered any issues moot. And so on that basis, there would be no need for me to trouble the court at any length. If, however, on the other hand, the court was against us, then I would have to address the court at some length as to the proper approach to satisfy the court that service of DIFC court proceedings, when being effected outside the Emirate of Dubai within the United Arab Emirates, must be in accordance with federal law, because it's within the sphere of the Federation's exclusive both legislative and regulatory jurisdiction from which there is no derogation. There would also be an opportunity for the court at an appellate level to settle some important issues as to the right approach to these applications under the Union Supreme Court Act, which have been dealt with at first instance, both by His Excellency Ali Al-Madhani in Fisk and Firouzeh, and also by Justice Sir Richard Field in Barclays and Essar. But there is an important debate as to whether the threshold test for the court to make a reference is one of a serious issue to be tried or question to be referred, or whether, as I believe my learned friend Mr. Montague Smith in fact submitted to Sir Richard Field, that the court should actually itself determine the question of constitutionality. If the court had time to deal with that and the question of how service of DIFC court proceedings should be effected outside the Emirate of Dubai, that would be of great interest and use to DIFC court practitioners at large. But for present purposes, if the court is with Mr. Flynn on my client's primary case as to why the appeal should succeed, all that the court need do is simply say that its reason for declining to give permission to refer my client to the Union Supreme Court is because it is unnecessary in this case, because the issues raised are moot.
Well, Mr. Taylor, leaving to one side the somewhat interorum nature of that submission, isn't there another basis upon which we could arrive at that position, and that is that the resolution of these issues and a reference of these issues to the Supreme Court should await a case in which it matters. And what I don't see is why it matters in this case, because there is no doubt that the documents were served. The receipt of the documents was acknowledged by Ms. Al-Jaber, and the jurisdiction has been consented to by the parties' participation in these proceedings. So any defect in relation to service has been cured by the entry into the court, the jurisdiction of the court, and the participation in the court. So I just don't see that, interesting though the points are, how would they make any difference to the outcome of this appeal?
Well, Your Honour, I would challenge all of those propositions that you've just made. But barring the first one, that if my client succeeds, it's all unnecessary, but it would not be academic for the reasons that Your Honour has just suggested, because
Why not?
The following reason is that whilst it is the case that the Part 8 claim form was served amongst other ways by courier delivery, that apart from some complaints we make about the directions that were given in the translation, which needn't concern us for a moment, is that the manner in which the hearing was notified, because you will search in vain in a Part 8 claim form for any indication of when the court is going to hear the matter. In contradistinction to a Part 7 claim, there is no provision for a necessity for a defence to be filed, although a defence and counterclaim can be. And the first and only indication of the hearing date, which under the federal rules, if it's going to be communicated electronically, must be done by the court, was communicated by this court the evening before the hearing took place.
All right. Well, now let's say all that's correct. An appeal would only be allowed on that basis if the brevity of notice mattered. The brevity of Mr. Flynn has conceded all the issues about procedure and the denial of adjournments only matter if his fundamental proposition is right. That is, that there should have been given time. If that fundamental proposition is right, the appeal will succeed. If the proposition is wrong, it doesn't matter that longer notice wasn't given, because the only thing that could have been put was a wrong proposition. Well, so whichever way you look at it, it can't impact the outcome of the appeal.
That discounts the arbitration point.
Well,
that discounts the point that in order to invoke the substantive right to arbitrate, you must have filed a timely acknowledgement of service, which, although one of the points in appeal is that the effect of that rule in depriving a client of that, depriving a litigant of that substantive right, is equivalent to or amounts to the sanction against which should be relieved. So, Your Honour, there are a number of points, but I'm entirely in the hands of the court. But I would have thought that the easiest way to proceed would be for Mr. Montague-Smith, and it's up to him how he wishes to do it as well, is to address the points that Mr. Flynn has made on the appeal, unless the court wishes me to address the longhand version of the reasons why this, I respectfully submit, this court should defer and refer to the Union Supreme Court to consider the constitutionality of these laws, which is an exercise in statutory construction which, according to the jurisprudence of this court, correct jurisprudence of this court, is the exclusive domain of the Union Supreme Court in Abu Dhabi. But that, I'm afraid, to make those submissions would take time. I would say I can do it in 45 minutes, but not less. So I'm in the hands of the court as to whether they would wish me to do that, or whether they would prefer to hear from Mr. Montague-Smith to see whether my very short submission that all the court needs say is that there's no need for a reference because the appeal succeeds in any event is the economical path that could be taken.
I don't know, Judge Ali and Judge Martin. Shall we hear what Montague has to say first?
Yes, that would be my preference, Chief Justice.
Okay, let's do that.
Yes, me too.
Oh, great.
But we have been going for 2 hours, though. I wonder if now would be a...
Okay, we'll take a break if you want to. Fine.
Oh, that's up to you. I'm just worried about counsel, all of that. But...
That's very kind. I'm very happy to do what I can. I mean, what we've got is a very new proposal from my learned friend, and I'll try to explain the difficulties that I have with it. It's a little bit unclear to me which of the... We've got 7 rounds of appeal, and we've got 5 questions that are supposed to be referred to the Union Supreme Court. So there's sort of 12 issues in principle for me to address. Now it may be that you don't want to hear from me on some of those, and that can speed things up. And I've got a sense of that perhaps from Mr. Flynn, but I don't want to leave anything out which then is held against me. And there's quite a lot of new allegations being made even at this stage of these proceedings as well. So I think I'm obviously give me direction if you have a clear view of what you want me to address. Otherwise, what I was going to do was just answer this new proposal first and give you my answer to my practical answer to the practical solution that's being provided, or the difficulties that I can see my client would have with it, and then move on and deal with the grounds in order, and you can move me through them as fast as you like, and I'm obviously in your hands. If that's acceptable, just to explain what would be the problem for the bank or in this new alternative? And as I understand what's being proposed, it's now being said that, all right, if the judge was unable to make an order nisi, for whatever reason, I think there would have been significant problems with that. Not just
before you proceed on, Tom. Wayne, you were mentioning about the break of 2 hours.
Oh no, I'm happy to press on as long as everybody else is happy with that.
Ali, you're right.
Well, I think Chief Justice, I think Mr. Montague Smith will go for not less than another 2 hours. I think then this is a sensible way that we take maybe short break, not more than half an hour. Then we have our another full go.
Yes.
Because we didn't want to interrupt him again.
So what we take about half an hour break now?
Maybe half an hour would be good.
Okay.
Yes. Thank you.
Thank you.
Right.
Thank you.
Thank you.
Because I think Ali has got to have his lunch. It's your lunch time, isn't it?
And Bray as well, yeah.
I'm grateful for an opportunity for my second breakfast as well. So
yes, good.
In half an hour's time, which is 5 o'clock my time, and Wayne, and Dubai is what?
1 o'clock.
1 o'clock. No, 1 o'clock. And then London would be what? 10 a.m. No.
9 a.m.
9 a.m.
9 a.m. 9 a.m. Okay, take a 30-minute break. Thank you.
Thank you.
Okay, we can resume. It's 5 o'clock now.
Thank you, Your Honour. Your Honour, I was going to, Chief Justice, I was going to deal, if it's acceptable, with this new alternative that's being proposed, first of all, if I may. And I've had a very brief opportunity, not a full opportunity, to discuss it with my clients. But I think that they have there are some difficulties that they have. I'm sorry, Justice Martin, can you hear me properly? Is that? I'm grateful. Yeah. You've seen my submissions where I make the point that up until very recently, Al Rihab was saying, well, this property is worth, I think it was put in a range of 170 to 205 million dirham, possibly 300 million dirham, and that the price that's being agreed appears to be around 148 million, depending on the value of the debt to DIFC investments. Is 108 million plus that. And so what appeared to be happening was an attempt to sell the property at an undervalue. Now, I accept
but Mr. Sorry, what's that got to do with you? Provided you're paid your secured debt, what's
two things.
What's that got to do with you?
Two things. Firstly, we do have, as you mentioned, an indirect interest in payments and value being received by Abu Dhabi Commercial Bank, because that money.
But that's an unsecured interest.
It's unsecured, yes, but
aren't you vulnerable to the criticism that what you are doing is seeking to translate your secured interest, to expand your secured interest, to protect your unsecured interest?
No, I'm answering the question, why are you interested in that? Yes, I'm interested in it for that practical reason. It's not, as you say, just prurient interest in maintaining status quo. I think the court ought to be interested in it. Why? For another reason, which is that if this is intended to be a mechanism to release value from Al Rihab, which it appears to be, or on Al Rihab's own case as to the valuation of the property, then that must be relevant to the exercise of the court's assessment or discretion, however you want to put it, as to what remedies ought to be granted at this stage. So what's being said now is Al Rihab should have been given more time. But what's now being said is not only that it should have been given more time, but it should be given that time from now. And so the perhaps more concrete concern that raises is that the sale, as we understand it, cannot go ahead, will not be able to go ahead. So it will be blocked. It will be blocked by DIFC Investments, who my learned friend does accept has a right to object and has said they will object. But also, it will be it's contrary to the terms of the CTA, the Common Terms Agreement. Now, why? And I'll show you the terms in a moment. My learned friend makes a surprising submission that Omniat is not a shareholder of Al Rihab. He also says, well, what counts as a related party? All of that is dealt with. The fact that his client is a shareholder is in his own evidence. The question of what is a related party is dealt with in the Common Terms Agreement. But the point of that is...
Sorry, Mr. Montague-Smith, what's all this got to do with us? I mean, we are not being asked to approve the Omniat transaction. That's no part of our function. Our only function is to ascertain whether under the mortgage you have been given more rights than you ought to have been given. And that is not a question, as it seems to me, that's answered by a detailed investigation of one of the possible transactions that might be undertaken if more time was given. It's not the only transaction that could be undertaken. If it's blocked, then they might try and find another buyer to whom these objections don't apply. But I must say, it seems to me there's force in Mr. Flynn's proposition that it's not our job at this stage to evaluate that proposed transaction. And especially in a context in which claims, for example, you claim it's undervalued, that's a claim that is only relevant if you are purporting to protect something other than your secured interest, because the price at which the sale will take place will pay you out in full.
I hear all of that. I hear all of that. I do have some submissions to make on it, though, which is that...
Yes, all right.
That what this court is supposed to be doing is looking at the judge's decision below and deciding what the judge should have done in that context. And then if your honours decide that he should have done something different, for example, he should have given the appellant more time, 6 months is what's suggested, then you have to look at the question, well, what would happen if you substituted that order? Or is it being said that in fact the judge should have given a year, because we are now more than 6 months after that hearing? And in order to determine that brings into relief the question, would it have made any difference if the court below had given the appellant 6 more months to make these payments? And we can see what the answer to that is. The answer to that is the only option that is on the table at the moment. And if one looks at the memorandum of agreement, the only option that Al Rihab can now pursue, as we understand it, in terms of a sale. Because if the appeal succeeds, then the agreement kicks in. Al Rihab is, according to that agreement, bound to sell to Omniad. And so if it is right that that is not, A, it hasn't happened, B, it isn't going to happen, then all you are doing is you are just extending out the time frame by another 6 months in circumstances when, had that happened at the time, it wouldn't have made any difference. And the point that was put against me in response to that issue was that, oh well, it's incredibly difficult to sell because they didn't have title. That's what was blocking it. Now, there's no evidence to suggest that. They appear to be picking up on a suggestion that Your Honour Justice Martin made, possibly this is the answer, at the last hearing. But there's no evidence to suggest it. So the first time it's come from the party is today. But that is no answer if the solution is, oh well, we're just going to make the order for foreclosure and then give them 6 months in which to redeem anyway and unwind that order, because then you're in exactly the same position that we've been in for the last 6 months. So what is
not quite, because the conditions would make it clear that if a sale could be achieved at a price that would pay out the bank, then foreclosure would be reversed. Whereas for the last 6 months, that's not been at all clear. The last 6 months, any party dealing with Al Rihab would say, well, I'm not dealing with the registered proprietor, and I don't know if they ever will become the registered proprietor.
But that depends entirely on the facts of what has been going on in the last 6 months, for which you just have no evidence. We're just speculating about that.
Yeah, we're also speculating what's going to happen in the next 6 months, Mr. Montague. We are speculating. You cannot say they cannot find a buyer. You cannot say they cannot find a buyer at a certain price, because we do not know. We have to give them a chance. Whether he gets a buyer or not, if you cannot get a buyer, he lost. He loses his piece of land. But if he gets a buyer, but we are not here to decide what will happen. You are asking us to say, oh, he's not going to get it. It's not for us to say so at this stage.
No, but I'm not, that's not my proposition. The point is this: what is the difference in outcome between what is now being proposed and the current position? Now, there was a suggestion from Justice Martin that there was a practical difference, which was that under the existing scenario, the money that is left over from the sale will go to Abu Dhabi Commercial Bank and not to Al Rihab. But that is in fact the practical situation at the moment as well. Because if you look at the disposal...
It's not relevant at all. Who the money goes to is not relevant at all. He puts the money on the table, the title is returned to him. That's what I've been saying from the beginning. They put the money on the table. Here's your 180 million, and maybe here's another 40 million for the IFC. You give me the document. Whether I can sell the piece of land, more expensive, less expensive, or I can't sell at all, that's my concern, my problem. That's not your problem. You got your money. Why should you be concerned with what I do with my piece of land?
Well, I've tried to explain that because of the restructuring, where there is now Al Rihab is indebted to Abu Dhabi Commercial Bank and through them the syndicate to the tune of 8 billion dirham. That's over $2 billion. And so it's not surprising that there are controls in place to ensure that.
But are these people secured creditors on that piece of land?
No, but they have contractual.
Secured on that piece of land.
No, they have contractual rights, and so
they're unsecured creditors.
But then, but how does this feed into? So, well, I'm trying to explain what my client's practical concerns are with the alternative.
Block the sale, but that's not for us to say. Of course, they can get together and block the sale if they want to. Block whatever Rihab is trying to do. They can. They're powerful people, but it's not for us to say so.
Well, they're not. They wouldn't be using their status to do that.
You're speculating.
I'm sorry?
They will be doing so.
I'm sorry?
You are speculating that they're going to be so. They're going to block the sale.
But I wasn't suggesting. You said, Chief Justice, you said that they're powerful people. It wasn't because they are who they are. It's because there are these arrangements pursuant to which the Al Jabeer Group has borrowed 8 billion dirham, and these are important and significant commercial relationships for this jurisdiction. And one of the assets that falls within that restructuring is this piece of land. And it's subject to legal rights, some of which are secured and some of which are not secured. That's absolutely right. But the question that I've been asked is, what's your problem with the practical question I was asked? What's your difficulty with this new proposal that's being made? My practical answer is twofold. A, that it looks like an attempt to remove value from an asset of an insolvent company. So it's stealing a march on creditors. Most judges would be concerned about that. Most courts would be concerned about that. That is something that we have concern about in the abstract and also in practice, because the bank has an interest in that money being paid off. It has a small percentage of the debt. But secondly, the point is that I think I can't do much better than the way that it was summarised by Justice Martin at the outset, which is that this is a party that's been in default since 2017. You will have seen the evidence which shows that there have been attempts, and my client was in favour of restructuring that debt, but the other parties weren't, the other syndicate members weren't, and therefore it wasn't restructured. Promises were made, and some attempts, a joint approach was made to the DIFC, I think 2 to 3 years ago, between Omniat and the claimant, and Omniat was told, come back if you're serious, and they didn't come back. And all this time has passed, all these warnings have been given, and then 6 months into the appeal, we're told, oh, well, the judge should have given them 6 months. And so now you're being asked, oh, well, actually give us another 6 months from now on. And so it is relevant in that context to look at the question, A, was it really wrong for the judge not to give them 6 months at that point? And B, if the judge had given them 6 months, what difference would it have made? And the answer is none. So that's why I'm bringing those issues to your attention. And then the further practical point that I raise is that, of course, this court is interested in making sure that that justice is done between the parties, that no one is illegitimately harmed by the way in which the judge approached the case. And that is why I say that there's simply no prospect of that, because as things currently stand, any surplus goes to Abu Dhabi Commercial Bank, and that would be the position anyway, even if...
How does your client lose or be in a worse position by giving Rihab another 6 months? What's the problem?
It's out of its money for 6 months. It's been out of its money for 3.5 years already.
3.5 years, another 6 months. They're going to get their interest.
Will we? Will we get the interest? Well, then, if you're happy to make that order, then that is not an issue.
When you take that land, you still got to sell it to somebody. The time taken to sell is going to take another 2 years. I can promise you that, Mr. Montague. You can tell your client that.
Well, the evidence
not going to go tomorrow and get the money day after tomorrow.
The evidence is that there's interest in it. So if you think that 6 months it isn't going to be possible to sell the property in 6 months, then what is the purpose of giving Al Rihab 6 months?
If Al Rihab can sell, that's all. But they cannot blame us for not giving them a chance. I know you're talking about the last 3 years, 4 years, 5 years, doesn't matter. But I'm looking at the so-called underdog as compared to the big boys, the banks. What does the bank lose by giving 6 months to these people?
I understand the sentiment. I do understand the concern about a company that's pitched against the bank. I don't think one can really characterise this as an underdog situation, though, because on the one hand, you've got
if the bank is going to lose everything, if you don't give it now, I could understand. But the bank has the land. It's just a matter of whether you get it now or you get it later. The land is the land, and the value of the land is not likely to go down. It's most likely keep on going up.
Well,
even if it goes down for a few months or 1 year, it goes up again. That is the nature of landed properties. If it go down and go up again, in the long run, it's the profit.
The other aspect of this is that a mortgagee has the benefit of where the mortgagor is in default. The mortgagee has various remedies under the law, one of which is foreclosure and one of which is the right to sell. So what I would say is that if you are attracted to this approach, why should it be the case that Emirates should not also be entitled to try to sell the property? That is the position that it would have had. That's the rights that it would have had under the mortgage all the way up to the 20th of June. Sorry, the 30th of June last year. And so it's not obvious to me why the court would say, fine, we'll make an order for foreclosure, but it's conditional on you not selling, because that was a right that at that time the bank actually had. Do you see what I'm saying? So if you're a lender and the borrower defaults and there's a mortgage in place, then the bank is entitled to take the property and go to the market anyway, and get their money that way. They don't have to come to court. That was one of the issues that was. Sorry.
But I expect Mr. Flynn's response to that would be that you, by your own inaction, had run out of time in which to sell the property, because you've clearly been. He would say you've been sitting on your hands. You had the mortgage due to expire on the 30th of June, and you hadn't attempted to exercise your right of sale. Having done that, you then came to the court and said, because we have, by our own inaction, run out of time in order to exercise our right of sale, we want you now to give us the extreme remedy of foreclosure. And in that circumstance, and now you're saying, well, having by your own inaction got that remedy, it's not for you to now say, well, we can make it the equivalent of the right of sale by giving these undertakings. What they say is the proper result should have been that the judge at the time should have built the conventional safeguards into that remedy, which is giving time, preserving the equity of redemption in effect by giving time within which to redeem, however that's done. So that as I understand, is the argument against you.
That's the argument that's been made today, and so we don't have full evidence in response to that as to what actually went on. You're not in the picture as to what actually went on in the run-up. You have some of the evidence in relation to that, and Mr. Wadhwani deals with in his witness statement. What I would say is it is grossly unfair to characterise what the bank did as sitting on its hands. Even on the 19th of April, the day before proceedings were issued, Rihab was asking for more time. Don't issue proceedings, give us more time. And in the run-up to that, there were lengthy attempts at negotiation, and promises were made and promises were broken. We will do this, we will take steps, we will give you authority to do X, all the way up to the 19th of April, the day before proceedings were issued. Now, this court rightly emphasises the public interest in encouraging parties to reach settlement without coming to court. There are all kinds of reasons why that is to be preferred. And if this court is to issue a judgment which says, well, you entered into negotiations for too long, you gave them too much...
You didn't have to come to court to exercise your power of sale. You could have exercised that any time from 2017 onwards.
I think that's right. That is right. I think that there was no decision of the court which said that. I agree that that is what the legislation means. A conservative approach was taken to that to get to seek a declaration to that effect. That is correct. But even up to even in this claim, that's one of the remedies that was being sought, albeit, and I can explain, that wasn't one of the remedies that was granted. But there was no precedent, no court precedent to that effect, and this is untested territory. So I think that the position was they just didn't know for certain that was the case. However, nevertheless, they were being asked to wait, not to take action. Proposals will come, and there is evidence to that effect. And in my submission, it's really, I mean, I do understand the way that the court looks at banks and lenders and has to make sure that there isn't one big party, one big bank that is bullying another party, that is using its financial might against another party. But you're dealing with an enterprise that has 30,000, on its own evidence, 30,000 employees. This is not some mum and dad operation. This is a very large multinational with its own legal department, 30,000 employees. It will have armies of accountants dealing with its accounts, and it is not the little person here. And negotiations were entered into, and in good faith, the bank did not issue proceedings until the 19th of April. And even then it did it in the face of pleas from Al Rihab not to issue those proceedings. And for Al Rihab then to turn around and say, oh, well, we asked you to delay, but now by delaying, that means you can't rely on your own rights. I mean, if that genuinely is the submission, then that seems to me to be incredibly unfair. And also, it flies in the face of, as I say, this court's encouragement of alternative dispute resolution. But in any event...
Mr. Montague-Smith, just one point before I forget. You've said a couple of times that irrespective of the undertaking that's now being proffered, even if there had been a conventional exercise of the mortgagee's power of sale, any surplus proceeds after the bank's debt had been paid would have had to go to ADBC. What's the basis for that assertion?
So in terms of if it was money that is two different ways. If it was money that's recovered by the bank, then
yes, well, I understand that. If it's money recovered by the bank, then it's caught. But if the bank sold as mortgagee, the extent of its recovery would be limited to the amount of its debt, and it would thereafter be obliged to account for the balance to the mortgagor, wouldn't it?
Yeah, but then the mortgagor has to pay it over to has to pay it over to the ADCB.
Bank.
And so,
but that's a contractual obligation. It's not a secured obligation.
That's correct. Yeah, that is correct. But it is the way in which the Al Rihab proposes to deal with the proceeds of sale in this case. And so, if you look at the memorandum of agreement, do you have that? So if you look at...
I do. I've got it in front of me.
If you look at paragraph 2, you'll see under the heading conditions, at paragraph 1 of this, box 2, paragraph 1 of that, you'll see that ADCB is defined as the agent. Do you see that?
Yes.
And then if you look at paragraph 4 of that same box, it talks about completion is subject to various conditions, one of which is receipt of a letter from the agent confirming the account into which remittance referred to in paragraph 42B is to be submitted. Then you see box 4 is the purchase price, and then payment requirements, paragraph 2A, such payment is first such amount as to the bank, and B, second, shall be paid into the account. So on Al Rihab's own structure, all money on the sale is going to go firstly to pay the bank, and secondly to pay Abu Dhabi Commercial Bank, and then also you see at paragraph 5 they retain the DIFC liability. So that's how they propose to deal with it. So the answer is that under their model of how this is going to proceed, ADCB gets any surplus in the property. Under our model, that's precisely what's going to happen anyway, with or without an undertaking, and we'll give that undertaking if that's an undertaking the court wants to have satisfaction. Literally, the only difference is who sells the property.
Well, but also perhaps the price.
Yeah,
so
well, that's
if,
right.
as you say, the 108 million dirham is undervalued, then after paying you out, there won't be much left to go to ADBC, will there? ADCB.
No, it's the other way around though, isn't it? Because if it's well, because they're offering to pay us 97 million. So you saw that in the offer.
Yes.
So
there'll be 11 million going to the Abu Dhabi bank.
Yeah.
Whereas if you sell it and get more than 160 million, then there might be more, because 40 million is going to DIFC.
Exactly.
So the difference is that Abu Dhabi Bank might get a bit more under your proposal, under theirs might get a bit less, provided you can sell it for the same amount or more.
Well, yes, but you'd expect that we can sell it for the same amount because Omniat wants it, so they'll buy it for that sum. So literally, the difference between the two proposals is that this proposal that's being made collars the sale at 108 million plus DIFC. That's the only price. That's the best price it's going to get. Whereas the other proposal allows us to drive the sale, put it on the open market, and get there, run the process. For example, if you want to ensure that is done properly, we're happy to give an undertaking. For example, you asked at the outset, are you happy to give an undertaking that it be done properly and to market value and within reasonable time and all the rest? Happy to give an undertaking that one of the big independent advisors on land sale be appointed to conduct the sale. It will be done. The difference is the open market.
Is that one is a sale done by the owner of the land. I mean, I would assume he wants the best price. The other one is by the mortgagee, who is just interested in getting what he is due to him. To stop.
But the first
if he can sell it for the price that the amount is owing, fine, he'll take the money and be happy with it. There's a major difference there.
But the first assumption's not right, and the reason it's not right is it is also in the memorandum of agreement, because you can see in the memorandum of agreement, if you go down to box 8, you see who's got conduct of this appeal. It is this appeal has been run by Omniat, and so they are the party who are given
No. That agreement was something you entered before the hearing at the CFI, isn't it?
No, I didn't. That's an agreement. So what's happened is Al Rihab have handed over their rights to Omniat in effect. And so Omniat does not have an interest in paying more than it can get away with paying. Whereas my client has an interest, and if you want to, it can be put in the hands of an independent advisor who will take steps to ensure that the sale is at market value. Omniat is a shareholder of Al Rihab, and we know that because Ms. Al Jabir says so. She says so in her witness statement, which was put back into the bundle this morning, which is in bundle 1 tab 5. If you go to page 35B of that,
just a minute. Yes.
And you go to paragraph 5. Al Rihab is a real estate company based in Abu Dhabi. The shareholders of Al Rihab are my father and Omniat 1 Limited. This is not just a throwaway statement as well, because she goes on. My father and Mr. Amjad are the nominated directors of Al Rihab and jointly have power and authority to manage the company. Recently, on the 17th of June, Omniat 1 Limited, in its capacity as shareholder, issued a power of attorney in favour of my father, authorising him to represent Al Rihab before the courts and to appoint attorneys for this purpose. So my learned friend says he doesn't accept that Omniat is a shareholder of Al Rihab. So you are being told two factually inconsistent things about the relationship between these two parties, and and as I say, you had this evidence before when Al Rihab was running the show that the value of the property was over 170 million dirham. You've got the submission now today. Oh, actually, our position is that we are overpaying for the property. What is the basis for that submission? There's certainly no evidence. Is there even any, I mean, is it just instructions? And if it is instructions, it's coming from Omniat. It's not coming from Al Rihab, and it's not coming from the market. So there are genuine concerns about what's going on here. You can say, well, what's your interest in it? We do have a financial interest in it, but the court ought to be interested in it as well. And the court ought clearly to be trying to make sure that justice is done between the parties and that everybody's legitimate interests are protected. And that does not mean the protection of Omniat's interest in getting this property for as little as it can pay for it. And if you are genuinely interested in protecting everybody's legitimate rights, then it seems to me you have to take this into account in deciding how to go forward from here. Because, as I say, if the submission is, well, the judge should have given them another 6 months to sell, we've gone way past 6 months already and they haven't sold. And so,
yeah, but they couldn't do anything within the last 6 months.
Well, that
Justice Wayne just said they couldn't do anything in the last 6 months. So how can you take that 6 months into consideration?
Because, well, they said, I mean, they were trying to sell it, and there was suggestion early on that a different seller had come in, as I understand it.
The fact is that they have in fact sold it within the 6 months.
Well, they've agreed to sell it.
They've agreed to sell it.
Yeah, I agree, but to a related party, a shareholder that they disclaim and say isn't a shareholder, at a price that they originally said was too low, but now they say it's fine. There's more going on here than meets the eye. Is the point? And I mean, I'll get into the question of orders nisi and whether or not this court has to go down that route. And I say it doesn't. But you know, the real fundamental question here is about whether or not the judge did the right thing, or whether or not somehow the judge should have done something different, should have given them more time, even though they didn't actually ask for it at the hearing. I've tried to explain to you why we have difficulties with a sale that is run by Al Rihab, or indeed probably going to be run by Omniat, because that's the way that the agreement appears to shape things. So this attempt to sell by a related interested party at a price which had previously been understood to be below market value. You've seen the evidence that the DIFC won't accept it, and so the question is, what's the point of giving them another 6 months? We have interest in the property. There's evidence of interest in the property, as I say, we can give you assurances as to how it is sold if that is something that concerns you. But we can get to a situation where everybody's rights are protected, as indeed we say they already are, by the situation as we currently have it.
Yes. Sorry, I have a question in relation to the memorandum of agreement between ODIFC Developments, the buyer, and Al Rihab. There are conditions to that agreement, the first of which is a successful outcome to the appeal, enabling the seller to complete the transaction without the bank or ADCB, in any capacity as restructuring agent, security agent, etc., or the finance parties having the right or ability to challenge the outcome of the appeal or the transaction. Now, I thought you said earlier that there was a prohibition upon selling the land to related parties.
Correct.
And if that's right, wouldn't that mean that even a successful outcome to the appeal wouldn't satisfy that condition, because the bank, the finance parties, would retain the ability to challenge the transaction?
Possibly. I mean, I haven't put much mind to it. I mean, I haven't got that far, and I mean, I think that on practical terms, though, you've seen what the commercial agreement is, and if there is a solution that Omniat is happy with, and given Omniat is in control of these proceedings, if you hear from Mr. Flynn that he agrees with X, Omniat agrees with it, then you would expect them to come to a conclusion that one way or another, this agreement kicks in.
Yes.
Would it be helpful if I showed you the provisions which show that A, a shareholder is a related party, and B, a related party can't be?
Yes.
All right.
I think that would be helpful.
All right. So I've shown you that Omniat is a shareholder on its own evidence. If you go then to the common terms agreement, you'll find it in bundle. I've got it in bundle 2, document 3, at page. We start at page 408 of the bundle. Yes. Sorry, I'm trying to get it up myself. So disposals. Do you have that? 18.15.
It's very hard. This is such a large exhibit. It's 1,200 pages. It takes a long time to load up. So perhaps you just better, if you can give me the details on the transcript and read relevant portions to me. Otherwise, I'll be here waiting. I'll be waiting 3 or 4 minutes to load the document.
I understand. It's for that reason that normally what I do is I download the PDF and work from a PDF on my desktop. The difficulty with that is that people then update the bundle, and so you end up with an incomplete bundle. But that's the only way that I've found that it's possible.
Well, I've taken a different approach, and that is to encourage the registry to punish people for putting in large single documents. But let's see if that works too. Right,
I'll make a note of that. Yeah, thank you. I was always told to put in one exhibit, for example, to an injunction, just so you've only got one set of page numbers. But I'll take that on board. All right. Yeah. So clause 18.15 says, except as permitted by paragraph B below, no obligor shall enter into a transaction or series of transactions to dispose of any asset. So it confines the way in which assets are disposed of. And paragraph A then carves out permitted disposals. It also carves out permitted transactions, but those aren't relevant for these purposes. So you have to look to the definition of permitted disposal. Before you go there, you can see at clause 18.16, under the heading arm's length basis, it says, subject to paragraph B below, no obligor shall enter into any transaction with any person except on not worse than arm's length terms and for full market value. And then carves out a number of types of transaction which aren't relevant. So what you have to do is you have to look at what is a permitted disposal, but basically that establishes the overarching position that everything has to be sold at market value and on terms which are not worse than arm's length. Then you go to permitted disposals, and those on page 309 of the same exhibit. So it's bundle 2, document 3, 309. I'm afraid even I'm going to take a little time to get there. I'm working from the actual page numbering, which is at the bottom of the page. And those set out a series of permitted disposals, and they all have to be taken. It says permitted disposals means any disposal which, except as set out in 18.16 arm's length basis, is on arm's length terms. So it has to be on arm's length terms, and then sets out the types of asset which might be disposed of. And when you get to real estate, the only one which is relevant is M, which basically says where the value is below 97 million. Otherwise, you need consent. But then, even there, subclause M says, it's the final words of it, such disposal is made in accordance with clause 20, disposals, consents and releases. And for land disposals, that means you have to comply with the consent conditions, and that the terms, the reference to that is on page 427, and it's clause 20.3a. But the consent conditions themselves are further up in the document on page 280. And if you look at C and D of those, if you've got them, those are the key ones. So consent conditions means, with respect to any relevant disposal, each of the following conditions. And then C is that the relevant disposal is on not worse than arm's length terms customary for such disposal. And D, the purchaser of the asset, the subject of that relevant disposal, is not, directly or indirectly, a shareholder or a shareholder affiliate. So the way the CTA works is to prohibit, and of course the CTA covers a vast number of different entities within the group, And so the way that the CTO works is to say certain types of disposal of property, of asset, are permitted. But where they're not generally permitted, then you need consents. But in any event, they're covered by these requirements. And when it's land, it's always got to be subject to these particular requirements, so that they can't be sold to a shareholder. Now, no doubt there could be an agreement that they can be sold to some other party, or you know, if the whole of the syndicate agreed, then it could go to Omniat. But while Omniat's a shareholder, it can't buy the property. But that really then goes to the question, well, look, you've got this agreement. This is the only solution that's been offered in the, what is it now, since in the 9 months since the proceedings were started, but in the 4 years since they've been in default, and despite the promises that have been made, and the solution comes very late in the day, and this request for another 6 months, which is in effect what it is not going to get to a conclusion which is any different from the one we already have, unless it is a worse conclusion because it means an off-market sale of the property. Your Honour, that's, I think, what I was going to say about that issue. Unless you've got any particular questions on my
when are you going to deal with the question of whether the judge was right or wrong to not give time?
Yeah, so I was going to deal with that. I mean, I was going to take the submissions that are made in order. I mean, I'm very happy to do it in any order you like.
Well, I must say, as I said to Mr. Flynn, I'm not terribly, from speaking entirely for myself, I'm not sure the procedural issues go anywhere, because when vexed with the plethora, to identify the plethora of defences, Mr. Flynn could only identify the 6 month point. So that's either a good point or it's not.
Yeah, I mean,
it just seems to me, if it's not a good point, then it doesn't matter, or the procedural issues don't matter, because it wouldn't have made any difference. If it is a good point, it'll succeed anyway.
I can see that. But again, one has to then just be careful what decision we're addressing, because when one gets to the question of 6 months, for example, you know, if it's right that there isn't some absolute rule that you have to give 6 months, then the question is, well, how much time should be given, if any, and is it arranged? And how does that work? And and then the question is, well, hang on, what was the judge actually being asked to do? And if the judge wasn't being asked to give them any more time, then unless there's some reason for that, good reason for that, then it's very difficult to criticise his decision on that basis.
But that's where the procedural issues come in, because the judge wasn't being asked to do anything. The judge wasn't being asked to do anything because of, like they say, there was a departure from proper process.
No, because the judge wasn't being asked to do anything, they say, because they didn't have an opportunity, they say, to get legal advice.
Yes.
And so that's why it's potentially relevant to look at these questions of adjournment, look at these other questions.
I understand. Yes, I understand that.
I mean, I don't know to what extent they're pursued, you see, and that's why it's difficult. I mean, I think if it was just a legal issue, if it was a purely legal issue, as it was presented as, which is, you know, can this court ever make an order absolute without first making an order nisi, then I could see the point. But even then, it would have to be on the basis that really an order nisi has to be made a certain period of time before the order absolute. Otherwise, it wouldn't have made any difference.
What's the normal practice in England? Is order nisi sort of freely or generously given?
It is generally given. I accept that in England it's generally given, and there's, I mean, it's been said that it's a principle of law. I'm not sure I'd accept that. I think it's a procedure that has grown up around foreclosure, and it's an old one, and I'll deal with it in due course if I may. But it's right that it's normally 6 months, but I wouldn't put it any higher than that. There's no rule of law that you have to give everybody 6 months. Now, in other jurisdictions, which I would say are more closely associated with the Torrens system, and in particular I've been able to look at the Australian position. I haven't been able to look more widely than that. It is not right that there is an order nisi process at all. There just isn't. And in fact, foreclosure isn't done in court at all. So there's no scope for that sort of process to grow up around it. And I'll address you on this, but when one actually looks at what foreclosure means under the terms of the law, it means vesting of the right of the vesting of the property in the bank, in the lender. And if that is right, then an order nisi is not an order for foreclosure at all. And so really all that's happening is what you're saying is that as a matter of process, the judge has to look at it and say, should I make the order for foreclosure now, or should I give them one last chance? And that is a much more, then you're a long way away from saying there's some sort of principle of law that this judge has got wrong. Really you're into the grounds of saying, in the circumstances of that case, what was the judge being asked to do? Was he being asked to give them more time? And if not, what are the reasons for that, and are they good reasons? And then secondly, had he been asked to give them more time at that stage, what would have been the right answer to that question in light of what he was being told at that stage and the evidence that was before him at that stage? And that is an evaluative decision, which shouldn't normally be something that this court should get involved in. But in any event, ultimately, the judge was considering that he was hard up against the deadline. Now, you said, well, that might be the bank's fault, and I've given you my submissions about why I say that's unfair. But then again, the fact is the judge made a decision about that period, and his decision was that given the amount of time and given the negotiations that have gone on, that Al Rihab couldn't really complain that it wasn't going to be given more time. So again, there really needs to be an attack on that decision. And that is another evaluative decision based on the facts that were presented to him. And if not based on those facts, then based on other facts which are being presented to you now, but on the basis that they couldn't be presented below for some good reason. Now, we just don't have that edifice of submission, of evidence, of explanation of why that case wasn't made out below. Now, I'll deal with that in the context of adjournment, but that ultimately is the difficulty that I have and have always had with the way in which this case is being pursued by Al Rihab.
So perhaps before you come to that, Mr. Montague-Smith, I wonder, you heard me really think aloud with Mr. Flynn about what the impact of making an order nisi order would have been if it had been made in June. And you've heard the views I've expressed. Do you have any submissions to put in relation to those propositions?
Sorry, so the submission is that they were prevented.
The proposition I put to Mr. Flynn was that really the only way that the judge could have protected the bank's security position was by proceeding straight to make an order for foreclosure. Yeah. Because if he hadn't, there wouldn't have been any vesting of proprietary interest, and the proprietary interest in the mortgage would have lapsed on the 30th of June, and the order nisi wouldn't have created any proprietary interest. Do you have any submission to put in relation to that?
No, I think I agree with you completely. All I'd say is that there are two problems with that. One is that if you make an order nisi, where is the power to make the order absolute once the mortgage has expired? Because if the order nisi is not an order for foreclosure, then the order absolute is the order for foreclosure, and the court has to make that order. And the right to make the right to obtain that order and the court's power to make it is predicated on there being a mortgage in place. And so that's the first problem. There's a logical problem there. The absolute order had to be made before the 30th of June. That's the first point. But the second point is the one I think that Your Honour was alighting on, which is that what happens between the order nisi and the order absolute. So assume you could make an order absolute after the expiry of the mortgage. In that intervening period, my client simply has no rights in relation to that property. Its right to sell the property is gone. There's nothing to protect, and so absent some sort of injunction, which would have to be based on legal grounds. But what legal grounds? It would have to effectively, my client would have to come to court effectively, probably, to justify a freezing order. But in those circumstances, it would be unsecured, and so it would probably need to get the syndicate involved because its interest, final interest, would be very limited in the outcome of an unsecured debt being enforced. So I agree with your Honour's position. I cannot see any solution other than that there had to be an order absolute by the 30th of June. But I just say that there are two reasons rather than the one. All right. Let me just go through the grounds as quickly as I can, if I may. I'm not going to quite take them in order, but I think I do have to deal, at least to some extent, with the adjournment issue as well, because that seems to be implicit in the submissions that's come subsequently. There was an argument about service, and I don't know whether we haven't heard anything about that. And it's not the Union Supreme Court issue on service. The argument on service was that yes, the documents were provided they were sent, physically sent, but also emailed to Al Rihab in time on the 21st of April. But the complaint, and that was accepted at the hearing, but the complaint was that Al Rihab was not told that it was not told that it was obliged to file a form for defending the claim. If it had been obliged, had been told that, then it would have realised it needed to dispute jurisdiction, and it would have taken the arbitration point. And that's the first way in which arbitration is brought in to this proceeding. And what's being said is a number of factual submissions are being made that receiving this notification that Al Rihab had to file a form for defending the claim would have prompted it to examine that form, would have prompted it to notice that it needed to dispute jurisdiction, and then presumably, although that's not explicit in the submissions, would have prompted it to realise that it had to invoke the arbitration clause under the common terms agreement. That's the way that the argument is put. Those are factual assertions, and there's no evidence to support them. There was an application at the court's invitation to adduce new evidence, and there's nothing in that new evidence which would support any of that. And we haven't heard anything about it today. But there are two major problems with this, and I'll skip right to those. And the clearest of those are, firstly, there is no form for defending a Part 8 claim. And the issue arises, and I can show you how it arises if you're interested. If we go to the rules, do you have the rules? They're actually in the authority. So it's Part 8. If we start there, and you'll see it's in the bundle of authorities at tab 11. But if you've got the rules separately, it might be simpler.
Yes.
So if you see at paragraph 8.61, where Part 8 procedure is followed, provision is made, and Part 16 does not apply. So the defence, the requirement to serve defences and replies does not apply. And then if you go down to 8.61d, do you see that? The requirement for the rule 7.35 to serve on the defendant a form for defending the claim does not apply. Why? Well, because there isn't one. There's no such thing as a form for defending a Part 8 claim, because there's no requirement to file defences for Part 8 claims. Now, the reason that there is this confusion is if you go up in the rules, and in the authorities bundle it's just 2 pages up, and so probably in the rules it's just 2 pages back, but to rule 735, you'll see this is about service of the claim form. When the claim form is served on a defendant, it must be accompanied by a cover letter indicating that a form for defending the claim, a form for admitting the claim, or a form for acknowledging service must be filed by the defendant using the court's e-filing system. So we've just seen the rule in Part 8, which disapplies that when you're dealing with Part 8 proceedings. And you'll see there's reference there to the court's e-filing system. So that rule has been updated when the e-filing system was introduced. And someone has obviously thought, well, we better update the position in relation to Part 8 too, and they've added in the new Rule 736, which says something different and incoherent, frankly. It says where the claimant is using the procedure set out in Part 8, the claimant must serve with the claim form a cover letter indicating that a form for defending the claim and so on must be filed. So this is a clear drafting error in the way those rules have been amended. But in any event, there is no form for defending a Part 8 claim. So unless everybody who's ever served a Part 8 claim is found to be in breach of the rules, or alternatively, every single claimant in a Part 8 claim is required to direct defendants to a form that just doesn't exist, then that's just simply an error. So that's what the appellants alighted on. But it also shows that the second half of the argument can't be correct, because if there's no form to serve, then there's nothing that can be looked at and acted on. And the other point to make about this is it's factually inconsistent with the rest of the case, because what's being said is, had they received that form, then they would have known that they had to take the arbitration point then. There's nothing in the form which would tell them that there was an arbitration agreement. And so the factual argument that's being run must therefore be that they knew about the arbitration agreement, but they didn't know that they had to rely on it at that stage. Now that is, it therefore means that it sort of blows a hole in this argument that they needed legal advice to tell them about their arbitration agreement. So ultimately it's incoherent in any event, because there isn't this form, and it couldn't lead them to the conclusion. But it does betray a problem with the case. And to be clear, save for the points about the not providing the form for defending, or not directing them to the form for defending, there's no complaint about service as a matter of DIFC law. What's said by Mr. Taylor is that the DIFC rules are unconstitutional because they allow party service. So I'll deal with that at the end, if I may. So there's just nothing in ground one, which is this service point. There's nothing in that. The second ground is the adjournment point. And I was going to just give your honours a little bit of context in relation to that, but I think we've been over the factual background to that. Just to give you the highlights, though, we're talking about a default that's been in place since 2016, and no interest even has been serviced since 2017. And the final repayment date for this loan was March 2018. And everybody knows that the mortgage expired on the 30th of June 2020. And so what happened was there were negotiations and discussions, and there's evidence of that. And then the respondent gave notice a year ago, on the 12th of January 2020, and said that it intended to enforce the security. And then all these notices were sent out, lots of notices were sent out to the ADCB and the other guarantors, which includes Mr. Al-Jabir himself personally, because he was a personal guarantor. And he was the person who sent his daughter, who's actually the CFO of the group, down to attend the hearing. And he's also the person who sought the adjournment in the first place. And so then there was further notices on the 13th of February, and then eventually on the 20th of April, the claim was issued. But before that, there were discussions between the parties. And during the course of those discussions, Rihab said it needed extra time so it could find a buyer for the property. That was in April, but there had been promises of action before then, and nothing had happened. And then, as I said before, the day before proceedings were issued, on the 19th of April, they asked for 3 months to propose a solution, which would have been after the mortgage expired. So I think the point is simply that in terms of when coming to the question of adjournment, you have to have that context in mind, because the judge was aware that the claim that Rihab can have been in no doubt that this was coming, that this action was about to come, and as I've said, it is a very substantial operation. Now, one thing that was said by Mr. Taylor in his submissions earlier was that only 1 day's notice was given of the hearing dates, and that's wrong. Ms. Al-Jabir previously in her evidence had said that they got 10 days notice of the hearing dates. I'll give you the reference to that. It's Bundle 1, Tab 5, page 35B, paragraph 9. That was in her evidence served after the hearing. At the hearing, she said something different again. At the hearing, what she said was that notification had been received in the last week of Ramadan. And the reference to that is Bundle 2, tab 7, page 1511. Ramadan ended.
And when was? Yeah.
Ramadan ended on the 23rd of May. And so that is consistent with Al Rihab receiving the notification that the bank received at the hearing, which was sent out on the 20th of May, not the 28th of May. And so it's simply not, they're certainly not right that they only received 1 day's notice. But I would suggest that the evidence that they only received 10 days notice is highly questionable, given what was said at the hearing, and fresh evidence, as you know. Actually, there's no application to introduce even the evidence that there is, but fresh evidence, as you know, has to be credible, and that test was devised in a case where the Court of Appeal said, well, actually, having said one thing, you just can't introduce evidence that you're saying something different because it's not credible. So we're in that territory, I'm afraid. So that is where we got to. They'd had, at least we say, from the 20th of May all the way up to the 4th of June. So they'd had a 14-day period to get ready for that hearing. And obviously they'd had 6 weeks in total since the proceedings were served. And it's only the afternoon or the evening before the hearing that Mr. Al-Jabir sent an application or sent a request for an adjournment. It is worth looking at this. You'll find it in Bundle 2 at tab 6. It's just a short email that was sent by him, because it goes to this question of where Al Rihab really was in its preparation. It's page 1503, and he says, following your email of the 20th of May, so you'll see there's a reference to that email, setting thereby the hearing date for the 4th of June, and due to the fact that we are still deliberating the file with the appointed law firm whom will be representing us for this case, especially with the lockdown we're facing, so on and so forth, and he says, which have caused delay in the appointment process, we seek your kind consideration and ask for an extension of 2 weeks to enable us to finish our discussions and finalise the procedures for issuing a notarised power of attorney in that respect. Asking for 2 weeks at that stage because they are still deliberating the file with the law firm. They needed to finalise the procedures. And that adjournment was refused. But there, and this came up again in some submissions subsequently, the complaint was that there was a problem getting a power of attorney put together. But a power of attorney, A, it's not required to appear in DIFC courts, but B, it doesn't stop you from receiving advice. So it doesn't actually explain why none of these points were made at the hearing at all. And so then we had Ms. Al-Jabir's attendance, and all she said was Part 8 shouldn't apply because there was a substantial dispute of fact, and that's at Bundle 2, tab 7, page 1510. And she asked for an adjournment of at least a month. So you've got two different times that are being asked for. And she said adjournment was being sought because they didn't have legal representation. It was the last week of Ramadan, and lockdown had made it hard to sort out legal representation. And it is, again, it's worth looking at her answers here. If we go in the same bundle 2, tab 7 to page 1511, she was asked, well, why didn't you sort this out before? There's really no good answer, at least. The answer comes back, as you know, our group, we are dealing with other situations which has a priority. So they had better things to be doing. And then she said, on the next page, we are talking to a firm, so that's consistent with her father's email. Then it says we have a lawyer, but our lawyer is not registered in the DIFC. And they took some time to see who is best. So again, it's not giving the judge the impression that they're just unable to do this. They're taking their time. They said themselves they're taking their time. And so the judge suggested a week. And then Ms. Al-Jabir said, oh, well, hopefully that'll be enough. And so it was pointed out to him that there's a big difference between needing a month and needing a week. And that there's an actual inconsistency there. It's not just a subjective analysis, well, we can just say we need a month and we need a week. Do they genuinely think they need a month? And if so, why is it immediately accepted that they can do it in a week? And the judge noted that this put in doubt the bona fides of the application. And then you get the response at 1518 all the way down the page to 1519, where she says, again, well, actually, she says, we're at the final stages with the lawyers, page 1518 at the first. And we've done a lot during the last week, she says. And if you give me a week, we'll be ready. And then the judge says, well, what's your defence? What actually is your defence? You haven't told me what your defence is. And there's no answer to that. So the point that's put against me, what's said against me is, well, our Rihab, and the way it was put by my own friend is, our Rihab was deprived of the chance to appoint lawyers. But there are a number of problems with that suggestion. The first is the obvious one. If they genuinely hadn't appointed lawyers, then that was their decision. They knew of the prospect of the action since January. They knew that the mortgage expired in June. They've been served in April. 6 weeks later, they should have got that in place. And what is the defence? Well, the defence is just going to be, we should have been given more time. We just should have been given more time. That's it. So this is a very substantial commercial organisation. Do they really need lawyers to tell the court, fine, make an order for foreclosure, but give us more time? It's not about orders nicely. It's not about understanding English legal process. It's just about saying, well, hang on, we need a last chance. If they wanted it, they could have asked for it. They didn't ask for it. And as I say, this is a substantial organisation with its own legal department. So, I mean, you know, and it's going to have accountants. If there genuinely was a dispute about how much was owed, and they've never put forward a positive case that anything was owed, but if there genuinely was that, then they would be in a position to know it. How can a company, a multinational with 30,000 employees, accountants and lawyers, not know how much it owes a bank? And when presented with a demand for years, how can they not be in a position at a hearing to say, well, actually, they've overstated it? I mean, in reality, there's just nothing in that at all. And similarly, you don't need a DIFC lawyer to tell you that if you've got an arbitration agreement, you need to rely on it before the trial. That's common to all systems. So if they've got lawyers, then that cannot explain in any way the failure to take that point at that stage. But then, secondly, it's not at all clear that it's right that they didn't have legal advice. So you will have seen, and they've been extremely coy on this. There's no evidence as to what advice they did take prior to the hearing. And you've seen the comments that were made in the various evidence. But importantly, Ms. Al-Jabir in the hearing referred to rules 8.16 and 8.17. So at the very least, she'd been prompted to take the court to that by a lawyer. She'd been given advice on DIFC law, procedural law, to that extent. And so if the submission really is, well, Al-Rihab's been deprived of the opportunity to get legal advice, you'd expect some explanation, you'd expect some evidence of what advice had actually been obtained. Your Honour's invited an application for fresh evidence. No evidence of that sort has been produced. There's no explanation, and it's quite clear that some advice what was given. Now, as to the approach to these sorts of applications, the court is entitled, I'm sorry about the background noise, I do apologise, it's not my dog. It's a feature of living in London, I'm afraid. I'm sure my learned friend doesn't have these problems. The court's entitled to be sceptical of last-minute adjournment applications, and that's the way that it's been put by Sir David Steele in the Corinth case. And the rule, which is 26.90, is that adjournment of a trial is an order of last resort. Now, there's some suggestion that that doesn't apply to Part 8 claims, but Part 8 sets out at Rule 8.6 the rules which are disapplied. That is not one of them. But in any event, it just reflects a sensible policy. And I think the court does need to consider the consequences of finding that the judge was wrong in this case not to adjourn. He was presented with no evidence whatsoever. He was told a series of inconsistent things about what the time was needed. There was a history of delay and empty promises. No defence could even be intimated, and no explanation was provided of why they weren't ready, other than we had other things to do. This is from a large organisation with access to lawyers, accountants and so on. The question for this call is, can it really be said that that is a decision, a case management decision, which is so far outwith the band of reasonable responses to the application that it should be overturned? If it is unreasonable, if that decision is unreasonable, it's very difficult to see what decisions are not unreasonable. It's very difficult to see what adjournment application would ever be refused in the future. If it's right that this party can just show up and say, I don't know what my defence will be, I'm not ready, I don't have a good reason, please give me an adjournment. You will be giving licence to judges, and indeed telling judges that they have to adjourn any time a party asks for it. There are two specific additional complaints now made in the recent submissions. The first is that the judge failed to take into account the impact on the appellant of the failure to adjourn. That's really just another way of saying that he got it wrong. Of course, the judge was well aware, as he says in terms, it's an important case for the client, for the defendant, and of course he was aware that the effect of refusing to adjourn was that they wouldn't be able to come back and with lawyers and mount further arguments. But the forfeiture was not the result of the judge refusing to adjourn. The forfeiture was the result of the default, which had been going on for years. And as I say, I won't go back over my submissions about what the current position is, but as I say, the current position is that Al Rihab's interests are protected. The actual forfeiture is neutral in terms of Al Rihab's interests. It hasn't affected Al Rihab negatively at all. If anything, the forfeiture, putting the property onto the open market, is in Al Rihab's interest. It's not in Omniat's interests, but it's in Al Rihab's interest, because the more money that is obtained for that property, the more debt is paid off for Al Rihab. It is a very small percentage of the total overall debt, but certainly forfeiture and putting the sale in the hands of Emirates and not simply allowing it to be sold off to Omniat is not against the interests of Al Rihab. And then the second point is that it's said that the judge wrongly took into account urgency, and that in part was based on this submission that there could have been an order nisi before the 30th and then 6 months afterwards. But I don't think that works. All the judge really said about adjournment, about urgency, is that he relied on it when questioning Al Rihab's motives for seeking an adjournment. The actual, at the hearing, and the reference is bundle 1, tab 7, page 1520, the judge's actual reason was no basis had been made out for adjournment. But in any event, all he was talking about with urgency was the fact that the mortgage was set to expire by the 30th of June, and the need to make orders to protect the position before that. So he was right to do that. I think the other part of this is that one then has to consider, well, what would have happened if an adjournment had been granted? And it is relevant in this context to make the point that even after the hearing, judgment didn't arrive for 11 days. Now, had the appellant, and the appellant did nothing, so had the appellant immediately got its acts together. Sorry, I just want to check that I've got everyone's connected.
Yes, I can hear you. I'm listening to you.
Had the appellant immediately got its act together and come back to the judge with submissions and said this is what our defence will be, then the judge would have had an opportunity to consider it at that stage in making his judgment. But they didn't do that. And so one of the suggestions by my learned friend is, well, there could have been a short adjournment, say for 7 days or something. But as we can see from the events that actually transpired, that wouldn't have made any difference. And the other point is, it can't be right that a party simply sits back to wait to see what happens, waits until after or right up until the point when the mortgage expires, and then getting a judgment doesn't like, challenging that on the basis that it should have had an opportunity to say something else. It should say what it wants to say, and it certainly had a chance to do that. And then, even after the judgment came out, it wasn't until the 18th of June the lawyers were appointed. That's according to Mr. Taylor's submissions, and they took 3 days to make their applications, try to set aside the order. Now that shows how quickly lawyers could have acted if Al Rihab had instructed them before the hearing, and gives the lie to the point that the argument that they couldn't have got themselves in a position to have lawyers acting before the hearing. And even then, no defence was raised other than, well, there's an arbitration agreement. This nice side point didn't come up.
Mr. Smith, I'm having a lot of trouble hearing you. I'm afraid there's something going wrong with your sound. I don't know if it's just mine. I don't know if others are having the same problem.
I am having similar problems, sir.
No, I hear him normally.
Oh, okay.
Yeah.
I don't know what's going on. Well.
I don't know what to do.
Try again.
I mean, should I just try again?
Yes.
And be a bit slower, perhaps. Do say if it persists, and I'll log out and log back in.
I can hear you. I don't know, but
I can hear him. Yes.
If I drop the video, it's suggested that perhaps that might assist. Should I try that?
Yes, it has helped for me too. Yeah.
Okay. All right. I've turned off the video, and hopefully you can hear me now.
That's much better. Thank you.
Thank you. So I apologise for that. It's one of the hazards of this process. The point I was making was that what difference would a short adjournment have made, and making the point that the appellant waited until after the hearing to see what was in the judgment before even bothering to appoint lawyers. And so you had the judgment came 11 days after the hearing. So the hearing, and then 14 days after the hearing, you get the appointment of lawyers, and in Mr. Taylor's firms. And then it's on the 18th of June, 21st of June, that you get this application to set aside. So there's 2 points there. One is, it can't be right that you apply for an adjournment, wait to see what happens, get refused, wait to see what happens, and only then try to appoint lawyers to try to make submissions. They could have made submissions in the meantime, but also it shows what would have happened, we say, if they had been given a short adjournment. And no defence was actually raised. It was said on the 21st of June, well, there's an arbitration agreement, but no dispute of fact was ever identified. They just said, I think at that stage, Ms. Al-Jabir said, we don't accept that they're entitled to foreclosure. That isn't even advanced at this stage. It wasn't until subsequently, I think it was in August, when the statement came in from Mr. Murhi in support of a stay application, that it was said, well, we don't agree with the interest calculation. So that's long after the final date when the hearing could have taken place. So it's hard to see how a refusal to grant a short adjournment could have resulted in any real prejudice here. It's only really if you take the view that the judge should have adjourned it past the 30th of June date that this could make any real difference. But the result of that adjournment would have been that we wouldn't have been entitled to any relief in my submission. So I do say that it's important to be consistent in these positions. Of course, the court wants to make sure that parties aren't unfairly prejudiced by these sorts of things, but parties, lawyers, we need to know what they can expect from the court on these sorts of applications. And the court ought to be quite careful about indulging behaviour of this sort. This is a modern commercial court based on the English civil procedure rules, which were designed in part to remove the scope for parties really to push back timetables like this for no good reason at all. That's all I had to say on adjournment, unless you've got any questions on that. Thank you. I was going to deal with ground 7 next, which is this idea that this assertion that the failure to allow Ms. Al-Jabir to make submissions at the hearing was also wrong in principle. the complaint is in the most recent skeleton argument, paragraph 60 to 63. I'll give you the reference in the future, and then I'll summarise. It's at bundle 1, tab 11, page 120. And the substantive complaint is that the judge didn't draw Ms. Al-Jabir's attention to Rule 8.16. Rule 8.16 is the rule that says where the defendant fails to file an acknowledgement of service and the time for doing so has expired, then the defendant may attend the hearing but may not take part in the hearing unless the court gives permission. And so the complaint is that the judge didn't tell Ms. Al-Jabir about that provision, and this misled her, as a matter of fact, into thinking that she couldn't participate under any circumstances, and that in turn meant she couldn't make submissions on the substance of the claim, and that harmed Rihab because it could have consented to various alternative relief that was being sought. And it's also said that that's inconsistent with allowing her to make submissions on adjournment. I'll make some short points in response to that, if I may. I'm losing video on everybody now, I'm afraid. It may be me.
I've turned my video off in the hope that it might improve the sound problem, which it seems to be doing. So
I'm grateful. Thank you.
Still there,
good. So the first point is that there's nothing wrong in principle with refusing to hear parties on Part A claims. That's the effect of the rule. And no doubt that rule will give way if a party has something that it wants to say and it's being given that right to say it doesn't prejudice the other party. I think the rule is probably designed to ensure that there isn't a sort of ambush at the hearing with new issues that would require new evidence and so on and so forth. But the fundamentally what's said is that Ms. Al-Jabir was misled by not being given that rule, because she was misled into thinking that there were no circumstances in which she could be heard. Again, there's no evidence to support that factual assertion, but in fact, what we can see from the transcript is that it is wrong anyway, because Ms. Al-Jabir clearly was aware of the terms of Rule 8.16. She referred to it. She referred to the terms of that specific rule. So she'd obviously looked at it. She'd been told about it by somebody. We don't know who. But you see reference to that, bundle 2, tab 7, page 1510. So it looks like she had some advice on that rule. But in any event, there's no submission, there's no evidence to support the submission that she was in fact misled. Nor is there any evidence that she would have made submissions on the substance if she'd been told about that rule. And in fact, again, the transcript shows something else, because when she was asked, what's your defense? She didn't say anything. And so this is a factual assertion that she would have made submissions on the substance if she had been known that she might be entitled to do so. And that is a factual assertion which is inconsistent with the case on adjournment. Because the case on adjournment is she didn't say these things because she didn't know what case to advance, because she hadn't been able to get legal advice. So you are being told two different things on this, factual things, by the same party. And then the only actual thing that is said that might have been different is that the submission is that Rihab could have consented to amendment of the relief which had been sought by my client. And that appears to misunderstand what was actually going on at the first hearing, because there were these two alternative packages of relief that were sought in the claim form. One package was amendment of the term of the mortgage to extend it, plus a declaration. And the judge said, I can't give you part of package 1 because of the way it was presented as a package. He said there was probably no need for a declaration anyway. And I'm starting to break up again, I'm told. Would you bear with me just for a minute, and I'll dial back in, and I hope that will resolve things. Would that be helpful?
Yes, I think it would.
I'm so sorry, this hasn't happened to me before, but I will do it now. Hello, can you hear me now?
Yes.
Yes.
I won't risk
Okay.
the camera for now, so I do apologise about
Okay.
this. I'm just dealing with this point about what might have been different. The only point that is made is that Al Rihab could have, or Miss Al Jabir could have consented to amendment of the relief that was being sought. But the problem, and the only thing that couldn't be obtained because there was a lack of consent, was a declaration. Because that, in fact, the amendment of the term of the mortgage wasn't pursued because it was recognised that the court had no power to amend that. So the suggestion really appears to be, well, Mr. Al Jabir could have consented to extend the mortgage at that stage. But here the submissions in the skeleton are more careful. In fact, they don't say she would have done that. They simply say that if she had been allowed to make submissions, she could have consented, but that was not an option because of her non-participation. That's paragraph 62 of their skeleton. They don't say she would have done that. And there's no evidence of that anyway. But in any event, that's not about submission. That's about an offer to amend the terms of the mortgage. So that's not done by submissions. That's done by an offer from Al Rihab to the bank. So there's really nothing in this. Judge Giles, she was aware of the rule. She could have asked Justice Giles to give her permission to speak, but she didn't do so, presumably because she didn't have anything to say, because that's their case. She didn't have anything to say because she didn't have legal advice. Again, I mean, I think, had she wanted to just say, well, give us another 6 months to sell the property, then she would have been quite in a position to say so. She would have tried to say so. She didn't try to say so. And this idea that this was brought about by the judge saying you can attend but you can't say anything is really an artificial construct. It's not based on any evidence. That's all I had to say about ground 7. I was going to then move on through the grounds to ground 3, 4 and 5. Again, I don't know how much you want me to deal with this. The third ground relates to the second hearing, which happened on the 22nd of June. And the judge was asked to grant relief from sanctions and, in effect, allow the appellant to apply for a stay in favour of arbitration at that stage, so after judgment. That is the context in which the arbitration issue is really raised, in addition to the service point. So the point is that the judge should have granted relief under Rule 4.49, which deals with relief from sanctions. 4.49, we might as well look at it, is in the bundle at Authorities tab 11, document 2, page 972. But you're probably familiar with it. It's a pretty famous part of the rules. And what it does is it says where there's been, on an application for relief from any sanction imposed for a failure to comply with any rule, practice, direction or court order, the court will consider all the circumstances. So it permits the court to relieve parties from sanctions which are imposed for failure to comply with rules, practice, directions or orders. The right to apply to refer a claim to arbitration arises under Article 13 of the arbitration law, not under any court law. And that is where the time limit is set for when a reference can be made. It doesn't impose a sanction. It's not a rule, a practice, direction or court order. And so Rule 449 just doesn't apply. Of course, there are lots of rules of law which aren't covered by this rule, which impose time limits. Contracts do it, limitation rules do it. Not every breach of a time limit or every failure to take up a right within an available time limit is covered by this rule. And the other point is that this rule can't be used to unwind a judgment. So if, for example, I fail to put in evidence and the case is decided against me, I can't apply for relief from sanctions for failing to put in evidence and say the judgment has to be set aside as a result, you might say that the judgment is one way or another caused or contributed to by the failure to submit evidence, but you can't say that the judgment is a sanction which is imposed for that failure. The other point is this on arbitration. In arbitration, if the clause is not invoked, the court just goes on to decide the claim, and the party waives the right to arbitration. And that comes from a short extract from Professor van den Berg. I'll just read it out and give you the reference. It's Authorities 10, tab 1, page 880. And what he says there, he goes through the history of the New York Convention from which that provision is based. And he says the history makes clear that if the party does not invoke the arbitration agreement, the court will retain competence to hear the case. It also implied that the non-invocation by a party of the arbitration agreement must be considered as a waiver, and he refers to tacit waiver. So the time to apply for a stay for arbitration was long past by the time of the hearing. It would have been, the time would have been at the time of the acknowledgement of service. And there were numerous other problems with this idea that a foreclosure claim was capable of arbitration or was covered by the arbitration agreement. And these are the points that Your Honour raised with my learned friend, that there are issues about the scope of the arbitration agreement and the fact that foreclosure is a court remedy. And the question of whether or not really, I mean, when one deals with the scope of the arbitration agreement, you understand that the CTA is covered by an arbitration agreement, but the mortgage agreement is not. And so what were the parties agreeing to do there? Were they really saying that before the bank could get foreclosure on a mortgage agreement which was due to expire by the 30th of June 2020, that the bank had to go through a whole process of arbitration, which would have taken, would have added another year to the process, then presumably get that arbitration award recognised and enforced in the DIFC, and then go to foreclosure?
Mr. Montague-Smith, why don't you help with this? Two things. First of all, you referred us to Article 13, which provides conventionally, consistently with the New York Convention, that the application for a stay must be made no later than when submitting his first statement on the substance of the dispute.
Yes.
Now, when do you say that Rihab submitted their first statement on the substance of the dispute in this case?
They didn't until after judgment. That's my point. But
right.
The point is that the twofold. Number one, that when one understands that provision in context and looks at the way it's been interpreted, particularly relying on the Van den Berg authority that I referred you to, it can be waived tacitly. So if you miss the deadline to do that, to provide your statement on the dispute, which has to come with the acknowledgement of service in a Part A claim, then you lose that right. Maybe that then lends itself to an application for an extension of time to submit an acknowledgement of service. And that is an application that was made by Rihab. They applied to the judge on the 22nd for a retrospective extension of time to submit an acknowledgement of service. He rejected that application. That is not appealed. So that's the first part.
My second question is, where exactly do we find the arbitration agreement? If you can just give me a trial bundle, an e-bundle reference, that would be helpful.
Yeah. Bear with me, please. It's in the Common Terms Agreement. So sorry. I think is it clause 28? Someone will come to my rescue. Sorry, it's 39. 39.2. Clause 39.2, and it is at page bundle 2, tab 3, page 478. Yep.
Thank you.
Sorry, the second half of my point was this, that even if it's wrong that you lose the right to arbitrate when the time to submit your defence expires, once you get to the point that the judge has actually decided the case, then there's nothing left to stay. And so the issue just becomes moot. So that's the point, that if a party doesn't invoke an arbitration agreement, the court has to go on and decide the claim. There's plenty of authority to that effect. It most often arises in the context of anti-suit injunctions, when one party is seeking a permanent anti-suit in favour of arbitration, the other party can't say, well, that final injunction is actually something governed by the arbitration agreement. And so in all of those authorities, the court said, well, given that the defendant can't say it because they're the one breaching the arbitration agreement, if they don't say it, nobody invokes arbitration. The court just has to go on and decide the claim. So if you've got past judgment, there's no scope for anything to be stayed, and that's the end of it. And then the final problem with this aspect of it, though, is that the question of whether the court should grant relief from sanctions is surrounded by law. There's been quite a lot of development of that in the United Kingdom, culminating largely in a Court of Appeal case called Denton. And that requires the court to go through a 3-stage test and look at the seriousness and significance of the breach, whether there's a good reason for it, and all the circumstances of the case. And so the more significant the breach, the more need there will be for a good reason, and the consequences of the breach are important. And so the application for relief from sanctions was being made on the 22nd of June 2020, which was only 8 days before the expiry of the mortgage. And all that was being said was, well, we want to go to arbitration. Even then, they weren't able to identify a factual dispute. So there's no real case mounted as to how they fit within those criteria and satisfy them. That's all I had to say on ground 3, relief from sanctions, and that issue about arbitration. Ground 4 is this assertion that there was a failure to observe requirements of mandatory law. I don't know whether you've had a chance to look at this. I find it quite a difficult argument to follow, and we haven't heard any submissions on it today. The argument is set out at Bundle 1, Tab 3, page 32. And as I understand it, essentially, yeah.
For myself, I don't know about the other members of the court. We've heard no oral argument on this. I'm happy to leave the matter on the basis of the papers, unless there's something you particularly want to say.
No.
So we can ask, what's his name, Mr. Flynn, to reply on those points or say something, because I never had opportunity to. Is it Mr. Flynn or is it Tim Taylor who's supposed to be submitting on this?
It's me, Chief Justice, Mr. Flynn.
Yeah. Okay. I suggest Mr. Montague, you just proceed on very briefly, and then we'll give an opportunity to Mr. Flynn to just also reply on that issue. Otherwise, we just leave it to us to read your skeleton.
Understood. I think that I'll try and be brief. I'll try and just summarise my position, and just so you've got the shape of it. There is detail in my skeleton, and I won't go back over it. The mortgage agreement itself does not contain a choice of law agreement. The argument, as I understand it, is somehow you have to import. You say that the mortgage agreement is subject to UAE law because it refers to the Dubai mortgage law. That then imports Article 249 of the Civil Code. The result of importing that provision is that the judge has to sua sponte decide whether there are exceptional circumstances of a public nature which have made performance of the contractual obligation impossible or oppressive, and if so, then whether to reduce those obligations. So there are a number of problems with this. The first is that the only reference to the Dubai mortgage law is to the remedies that are available under it. So the whole of the Dubai mortgage law is not imported. The second is that the Dubai mortgage law only introduces the civil code to the extent that matters are not covered in the mortgage law. So there's a logical hole in the appellant's case here, because the amendment agreement, which introduces reference to this law, gives the right to take action in accordance with the mortgage law. So it's pointing to things that are in the mortgage law. And the mortgage law only imports provisions of the civil code which are not in the mortgage law. So there's no way to get there. And then there are further problems, though, because the relevant obligations, the payment obligations, arose under the Common Terms Agreement, and that's governed by English law. There's no reference to the mortgage law at all. So if the problem is we can't pay, well, those obligations arise under the CTA. And then the final problem is the factual one, which is that there is no evidence and no reason to suggest that the pandemic, which is what's relied on, was what caused the default. Why not? Because the default started years ago. So otherwise, I'll just rest on my written submissions on that, and I won't take it any further if that's
okay. Thank you. Thank you.
Ground 5 is the position of Abu Dhabi Commercial Bank. I don't know to what extent that's pursued, and I appreciate some guidance on that, because I don't want to waste the court's time taking you through the real property law on this. I think I heard my learned friend say, well, it's now revealed that Abu Dhabi Commercial Bank didn't have a mortgage, didn't have a second mortgage. If that is accepted, then it seems to me ground 5 falls away. And if my learned friend can confirm that, then I won't bother everybody with what I have to say about it. Is that the position? Have I misunderstood?
I think I made the position clear, but if I haven't, let me, which is that we accept that it's now been made clear that it appears that there isn't a second mortgage, but that is still a matter which the court should have taken into account at first instance. Indeed, my submission was, even if there was no evidence on anything, the court could only proceed to a foreclosure order if it was satisfied that there weren't other interests engaged. So the issue is still there, because one looks at this at the position of the timing of the judge looked at it. But we do accept that, looking at it as of today, it appears that there wasn't a second mortgage by ADCP. But it's still a matter which is live.
Thank you. Yeah, no, I think it's my misunderstanding of that. And I must say I'm still not quite clear whether or not ground 5 is pursued, because as I understand ground 5 is based on the assertion that there is a mortgage, a second mortgage, albeit unregistered, in favour of Abu Dhabi Commercial Bank. So my submissions were based on, firstly, assessing that factual allegation, which is now accepted to be wrong, and secondly, looking at the position, if there's an unregistered mortgage, does that give any rights over the property? In my submission, it's very clear on the face of the legislation, it does not. An unregistered mortgage does not. I've set out the law in my skeleton argument. There's been no real response to those points. Insofar as the position of Abu Dhabi Commercial Bank is relevant to the question of order NISO, which I'm about to come on to, then I'll pick it up there. But otherwise, I don't think I need to go into detail on those submissions, unless there's anything you'd like me to address you on in relation to that.
No, okay.
Thank you. All right. And then the final point on the appeal then, which is this order NISO point. And that is that, as I'd understood the proposition, that as a matter of DIFC law, the judge was only entitled to make an order NISO in the first instance. Now, that is argued clearly, that is a procedural approach that is taken in English law, but there are no corresponding rules anywhere in DIFC law. So the submission is purely on the basis of English law. And my submission is that the DIFC law on real property takes what I would term as a hard Torrens approach. So it's unlike in many respects the English approach to the law of property. And it's not quite, I mean, it's similar to the law in Australia. It's much closer to aspects of the law in Australia. But even there, that law is informed by the fact that Australian law has to deal with two different types of property. So it has a mixed system in most states, whereby some of the land is governed by Torrens rules and some of it is not. And so you'll see reference in authority to non-Torrens or Torrens land and so forth. But in Australia, which, as I say, is the only, I mean, it said, oh, well, everyone does this apart from Australia. My own friend produces authority only from England, which we can see clearly is different from DIFC law. But there are much closer parallels with Australian law. And in Australia, in most of the states, it's an administrative process. So you go to the land registry and you make your application. It's a procedural application and it's a box ticking exercise. There's no hearings. You just have to satisfy the registrar that certain conditions apply. And it doesn't come to court at all. Now, there are safeguards in place.
But is it ever done, Mr. Montague Smith? Because as I said to you last time we were here, I've never heard of foreclosure, and I can't imagine the registrars would do it.
But they'd have to.
Talking about Dubai? Sorry, the IFC?
No, I'm talking about Australia.
Oh, you're talking about Australia.
No, clearly it's available, but never been done in the DIFC. That's as far as we can see. That's right. I don't have evidence of what happens in relation to foreclosure in Australia, but the conditions are set out in legislation, and so there would be no opportunity for a registrar to say, well, you've satisfied the conditions, but I'm not going to grant you that remedy, because it's an administrative function. It's not a judicial decision. There's no scope to look at those conditions and say, well, yes, strictly that's satisfied, but I have a discretion that exists, and I'm going to exercise it against you. Clearly, if an unlawful order is made, the conditions have not been satisfied and foreclosure is granted. The conditions have been satisfied and foreclosure is not granted. Well, then you would have an application for judicial review, which would be available to come to the court. And I haven't found any examples of that happening in Australia, and it may well be the case that it's an unusual remedy as it is in England. My own friend said, I accept now that it's an unusual remedy. I accepted before the judge below that it was an unusual remedy in England, and I'll come on to why and whether that makes a difference in this case. But in Australia, the point is that under the legislation, the safeguards that there are, and there undoubtedly are safeguards, are backward looking. And so the laws generally, they're different, but the laws where it's an administrative procedure, the laws generally require, for example, that the borrower be in default for a minimum of 6 months. That's one of the requirements. That attempts have been made to sell the property beforehand, sometimes that applies, and that the mortgagor has been served. But once those things have been established, then there's no discretion. It's just administrative. So there is no opportunity for a practice to emerge of requiring orders nisi or requiring more time, because there are time limits built into the legislation. And so it wouldn't be lawful for a registrar to say, well, actually, I'm going to apply a different test. That would be that would be the unlawful exercise of an administrative power. So in my submission, it's not right to suggest that foreclosure without an order nisi is a novel remedy. Now, in the DIFC, the protections that are given are that parties be given appropriate notice, but also you have the Torrens system of land registration itself, which protects third-party interests. Now, the notice obligations can be very extensive, and this case is an example of where actually complying with those notice obligations was very onerous. There's a lot of evidence about that, and it took a long time and cost a lot of money. But again, the key here is that under the law, the safeguards that are in place are backwards looking. So I say that there is no basis to introduce some further procedural hurdle or procedural intermediate step, which derives from English law, which were developed on Rihab's own case on the basis of principles that are now barely used and haven't been developed for hundreds of years. The purpose of those safeguards is presumably to ensure that the mortgagee is given a proper opportunity to redeem. That's got to be, I mean, I can accept that is something that should be in the judge's mind. Has the mortgagee been given a proper opportunity to redeem? But requiring that proper opportunity be given after the first hearing is simply arbitrary. What matters is that they are given a proper hearing, a proper opportunity. And the other part of it, presumably, is to ensure that interested parties are protected. But that, I have to say, is different when you have a system of land registration as you have in the DIFC, because the Torrens system requires registration of all interests in land, and if it's not registered, it doesn't exist. My submissions in relation to the previous ground go to that. So interested parties are automatically protected under the Torrens system, and all that's left is this question of whether or not the mortgagor, the borrower, has been given a proper opportunity to redeem. I don't accept that it's a draconian remedy in every case. That depends entirely on the circumstances. And of course it can be a draconian remedy if only a small amount remains outstanding under a loan and the property is worth much, much more than that. Well, then of course it can be used in a way that's unfair and have unfair results. But that depends on the circumstances of the case. Here, there is no harm to Al Rihab because, as we pointed out, all of the excess goes to Abu Dhabi Commercial Bank, which is where it would have to go anyway under the agreements that have been entered into by Al Rihab. So its net position is not affected by foreclosure. All that really happens is that the power to control the sale passes from Al Rihab to the bank. And as we know, the only real reason to use foreclosure in this case was the unusual situation of the terms of the mortgage, which is that it was expressed to expire. That is unusual to English and Australian eyes, not, I'm told, unusual in the market, because that's a relatively normal practice in the UAE. But the result of foreclosure in these circumstances is a one-way bet for the bank. There's no upside but potential downside. So it's potentially a bad answer, bad solution for the bank. Why? Because if the value of the land is worth less than the loan plus the DIFC obligation, the bank's going to lose out. Because the effect of foreclosure, at least in English law, is untested in the DIFC, in English law, is that the obligation is extinguished, the loan is extinguished. So you're swapping your loan for a property that's worth less than the loan. So depending on the value of the property, foreclosure could be bad for the bank. But if the value is more, there's no upside to the bank because the excess goes to Abu Dhabi Commercial Bank. So it's a one-way bet. That's why one of the reasons why foreclosure is such an unusual remedy in these days, because it is almost always a one-way bet like that. And if it's not a one, and it's made a one-way bet usually by legislation in England, for example, in a consumer context, if there's any excess, it has to be paid back to the consumer. But so when we're looking, I think when you look at this, then the other point is that it's not obvious that there's any room in the law for an order nisi, because as I mentioned, an order nisi, as it's understood in England, could not be an order for foreclosure, because foreclosure is defined in Article 70 by reference to its consequences. When you have an order for foreclosure, then the title transfers. So an order nisi, unless it carries title, isn't, and that's a feature of, that's a logical consequence of features of this system, because a mortgage, unlike in England, doesn't involve the bank taking title. So in England, a mortgage, the bank has title, and then there's this equity of redemption, and that's not the position. Yeah.
Well, Mr. Montague, as I understand it, the position has moved since this morning, and that is that it's no longer contended that the judge should have granted an order nisi, because it's accepted that would have deprived the bank of its security after the 30th of June. So I'm not sure that we need to spend a lot of time worrying about the effects of the order nisi. The proposition, as I understand it, that emerged during the course of argument, is that yes, the judge should have either done nothing, leave that to one side, or he should have made the foreclosure order, but subject to conditions which would have preserved the equity of redemption for 6 months.
Yeah.
So I think as I understand Mr. Flynn's argument, that's the challenge you're facing.
I understand. So then you have to look at the question of what the judge was being asked to do at the time. And the judge was being asked to adjourn, and it wasn't being said, give us 6 months to sell. That just simply wasn't being sought. So can it be right that the judge can be criticised and his judgment overturned on the basis that he didn't do something that he wasn't asked to do. Now, if it is said he wasn't asked to do that because Rihab hadn't been given an opportunity to get legal advice, well, then you have to examine those submissions about adjournment and decide whether or not A, it really hadn't been given that opportunity, B, even if it really hadn't taken that opportunity, it does look like it got some advice, and C, does it need legal advice to say to the court, give us 6 more months? Does it really need that? So why weren't they asked to do that? But more to the point, if they had made that argument, then the judge no doubt would have examined this question of whether or not they had already had adequate opportunity to redeem the mortgage. Have they had a proper opportunity to redeem the mortgage? As I say, if you depart from this point about order nisi being some sort of legal requirement, then you can see that the distinction between time coming after the order and time coming before the order, or time coming after the first hearing and time coming before the first hearing, is an arbitrary one if the test is really, have they had a proper opportunity to redeem? And the judge was perfectly entitled, and indeed right, to look at the history of the loan, look at the history of the negotiations and the promises that had been made and not met, and say they've had every chance in the world to sell the property. Now let the bank sell the property for them, effectively. And that's really what the effect of the order was. So is it right for this court to come in and say, no, the judge got it so wrong that in exercising his evaluative judgment, he came to a decision that was outside the bounds, the reasonable bounds that were available? And unless you buy into this suggestion that the proper opportunity has to be one last proper opportunity after the court gets its hands on it, then there's no real scope for reaching that conclusion in my submission. There's no material that can be pointed to say that they hadn't had a proper opportunity. They clearly had a proper opportunity to redeem for years. If you do think the judge didn't have the opportunity, should have given them some further opportunity, that they hadn't had the proper opportunity to do it, then you're into my submissions about really the 6 months. What would have happened if they'd said we need 6 months? Why would that have been any different? And I hear what you say. Maybe there would have been different circumstances. It's very difficult to say. But you're in that difficult position. We're told the court shouldn't get into that. That's effectively my learned friend saying, well, I'm going to make a submission, but you can't answer it. I'm going to argue something I didn't argue below, but you can't come back on me on it. If there are difficulties in making that assessment at the Court of Appeal stage, that is a strong reason not to interfere with a first instance judge's decision on it. In fact, it's the very reason why fresh points on appeal are generally not allowed to be introduced if it would result in a different factual investigation, which it plainly would if the question, if Miss Al-Jabir had put up her hand at the hearing below and said, fine, if you're going to make an order for foreclosure, at least give us 6 months and don't let the bank sell in that period, at least give us 6 months to sell, then we would have had an investigation of why they needed that 6 months, whether that 6 months was likely to be successful. We would have had an investigation of whether or not the opportunity they've already had was sufficient.
Yeah, but Miss Al-Jabir is not a lawyer. I mean, she may not be aware about all these order nisi and things like that.
You don't need to be aware of all
that come after lawyers are appointed.
Well, it's a. I mean, we've all been involved in case. You have all been involved in cases for longer than I've been involved in cases. I'm sure we've all seen cases where parties attend court by themselves without their lawyers because they think they're going to get a softer time from the tribunal. Now, that is generally approached with a degree of scepticism, even when you're dealing with an individual. Ms. Al-Jabir is not a young lady, as she was originally presented as, appearing on behalf of her father. She's the chief financial officer of the Al-Jabir Group, which is a massive multinational corporation with its own legal department. So she could have sent a lawyer to court. She could have sent one of the in-house lawyers to court. She plainly, Al Rihab plainly could have appointed lawyers. But even if you don't accept any of that, you don't need a lawyer to say, give us another 6 months to sell this property. And that would have been the issue that would have been investigated. But it can't be held against me that there hasn't been that investigation, because the point wasn't raised below by Al Rihab. It was for Al Rihab to raise the point. So if the question is, have they had enough opportunity, the answer is, in my view, plainly yes. Or at the very least, this court is not in a position to say that the judge was wrong to find that they had that opportunity. That is a finding that is made. It's not, at least in terms, appealed by the appellant in this proceedings. But if it was, it seems to me hopeless to attack a judge's determination in circumstances such as this. And as I say, the court is always going to have in mind what are the consequences, what are the practical consequences of what happened. Has it rendered injustice to any party? And the answer, very plainly in this case, is no, because of all of the submissions I've made about the consequences of the existing judgment that's in place. If you don't give that, if you just give them another 6 months, we're going to end up having a big battle about whether they're selling at an undervalue, whether they're selling to a related party, whether they can be restrained from doing so. Legal costs are going to increase. We're going to have endless more litigation. And in my submission, they're just, whether you look at it from a legal perspective, strict legal perspective, or whether you look at it from a practical perspective, there is just no basis to say this is a case where everything should be put back to the position that it was previously, or indeed maintained, but requiring no sale and allowing the Al Rihab to apply. And we have to see the order that's being proposed in any event, but it's very difficult to see how that's going to work exactly in precise terms. And the other thing is, one of the questions that was raised in the course of my own friend's submissions was, well, on what basis could the court grant a caveat? It is right that the court could grant a caveat. I didn't make a note of this, but I've put it somewhere. I can't find it. But it would need an injunction. You'd have to make an injunction against the bank. So an undertaking wouldn't be sufficient. So that is Article 108 of the Real Property Law, which is at Authorities Bundle 1, Tab 5. If you go down to page 4AL, is where I've got it anyway. And that sets out the basis on which it states who may apply for caveats. And it says, to the extent that a real property interest or a real property right may not be registered in respect of the affected lot, a caveat may be registered in relation to such real property interest or real property right by any of the following persons. So that's Article 108. What you need is a real property interest or a real property right as defined. And then after that, you need an injunction at the very least to fit within 108 subsection 1C. So it's difficult to see how this works as a matter of law. I'd need to take instructions, but I can imagine if this court was going to say, well, we're happy to dismiss the appeal, but these are the conditions, you have to give an undertaking, and we're going to make a slight amendment to say, you know, that Al Rihab can apply to court or whatever to set aside the foreclosure in certain circumstances which would need to be defined, then I'm sure I'll take instructions on any undertaking to that effect. But as I say, I mean, this seems like a very complicated solution to a problem that doesn't exist other than for Omniat, because it's only Omniat's interest in getting this property sold at this price. And they are the only party who has no legitimate interest in the outcome of these proceedings. But broadly, I think I've made my submissions in relation to timing generally, and ultimately we're just sort of kicking the can down the road You do need to look at what the likely outcome of that is, it seems to me, if that is the order that you're proposing to make. But fundamentally, I say, you should be addressing this by reference to whether what the judge did was wrong. And given what he was faced with, in my submission, that's very difficult. That's very difficult. Your Honours, I think that's all I wanted to say about Orders Nisi. I do have some submissions on the Union Supreme Court, you'll be glad to know. I've tried to condense them, and I think I can get through them in 25 minutes, which I think, given the length of them, I hope isn't excessive, but I don't know whether you want to hear me on them.
Well, do they augment what's in your written skeleton, Mr. Montague-Smith? Because I've read those, and I've read the skeleton which presumably was prepared by Mr. Taylor. I'm not sure that I need much more than that, frankly.
Well, I mean, I'm always, I'm a barrister, so I always think that oral argument is helpful, but judges tend to differ on whether that's true. I mean, if there are any points...
I'll see what the other...
Yeah.
I'll see what the other members of the court think. Chief Justice?
Yes, sorry.
Yeah, the question is, do we want to hear argument from Mr. Montague-Smith in relation to the reference to the Union Supreme Court?
To be fair to Tim Taylor, we sort of asked him to hold on to what he wanted to say earlier. So if we hear, what's his name? If you hear Mr. Montague-Smith, then we have to give an opportunity to Tim Taylor to reply. But Mr. Tim Taylor, have you put anything in writing on that issue?
Yes, there's a lengthy submission from Mr. Taylor in relation support of their reference to the Supreme Court.
Then we'll just go through the written submission by both parties then.
Yes, I think Mr. Taylor has a detailed submission, his supplementary skeleton argument.
The only, if I may, the only thing I would say is that the consequence of a submission to the Union Supreme Court is a stay of the proceedings, as I'm sure members of the bench know pretty well. That stay will be pending a decision by the Union Supreme Court, which can take upwards of 2 years.
No, so, 6 months maybe.
Oh, is that right? Well, thank you. I understood 2 years. Thank you. Well, there we go. You know better than me then. But there is this principal question about whether or not what standard this court needs to be satisfied of the complaint of unconstitutionality. And I think from my learned friend's submissions, he's going to say you just need a good arguable case. What I would say is that in every case that the DIFC court has considered a constitutionality objection, it has ultimately looked at the question and decided it, and then said, and therefore there's no, whether the test is good arguable case or not, we're not going to make a reference. There have been a number of these sorts of submissions made in the past. None of them have been successful. But I just wanted to draw, as you already know, your attention to the consequences of a submission. It's not, it does put everything off.
I think we'll wait. Shall we just read from the submission?
That would be my preference, to deal with it entirely on the papers, but...
Understood, thank you.
Me too, yes.
If I may
Yes,
say,
anything, Mr. Ali? Yes, Ali?
if I may say, Chief Justice, there
I'm good with submission.
might be some very short observations that I would want to make, partly arising in connection with how the service point under the Union Supreme Court law arises, which is merely that Mr. Montague-Smith, in his submissions, made the point that it was incorrect to say that service had not been effected until the evening before. I was very particular to say that service by the DIFC courts was not effected by email until the evening before. That is a technical point, but an important technical point, because in my respectful submission, since both the legislative and regulatory power to provide for the service, means of service of process from one emirate in another is entirely within the federal remit, with no derogation, as there is for other major laws of civil procedure. That provision must be provided. The relevant provision is in Federal Resolution 57 of 2018, which is at page 176 of the authorities bundle. That provides that where electronic means of service are to be used, that can only be done by the court. Now, why this is not a purely technical submission is that what one can see from the history of how these proceedings came to be served, I would just ask the court to note the following, which I can do simply by giving bundle references and making the points. The first point is that the form of a Part 8 claim, and the Part 8 claim in this case is to be found at page 222 of the bundle and runs to 226. It plainly does not include any date upon which the party is required to appear at court. As you've already heard from Mr. Montague-Smith, Part 8 doesn't require a defence. It merely requires an acknowledgement of service, which must be filed in order for on a timely basis, in order for the defendant to challenge jurisdiction by asserting an arbitration clause, and that's Rule 12.2, which says that a defendant who wishes to contest jurisdiction must file an acknowledgement. That's the sanction that's relieved. There is therefore, the question becomes, at what point did our Rihab become aware that they must turn up in court? Now, it is true, as Mr. Montague-Smith says, and it is helpful to look at the exchanges of emails in the bundle, which run from 1502 to 1507, because what one will see, looking very carefully, one has to read backwards in the emails. The Part 8 claim form, as served, contained email addresses for the claimant, which of course gives the necessary consent for the claimant to be served by email as required under the rules rules of the DIFC courts, which permit email service provided there is consent. The Part 8 claim form also contained email addresses for various parties at the respondent. But unless and until an acknowledgement had been filed, which it never was, the registry would not have begun to communicate with the respondent by email because the necessary consent would not have arisen. So what one sees is that the basis upon which notice that there was going to be a hearing on the 4th of June came to the attention of the respondent was by chance, in that the claimant, in having responded to the DIFC registry, CC'd the email addresses at the Al Jaber group, and that is, in that trailing email, the court had given notice to the claimant that it proposed to hold a hearing on the 4th of June. Now, that, in the Part 8 procedure, would be the first occasion upon which a respondent was required to put forth its defence, because unlike with the Part 7 procedure, the rules do not provide for service of a defence. Now, that email having been picked up in the trailing email, one sees that there was, the evidence shows that this was an email prepared by Miss Al-Jaber's father, who has little English, with assistance. There was an email on the morning of the 3rd of June, which one finds at page 1504 of the bundle, I think. Apologies, you find it at page 1503.
Mr. Taylor, did Ms. Al-Jaber say that she had 10 days? On one occasion, she said she was aware of the hearing 10 days before it took place, and on another occasion, she was aware of the hearing in the last week of Ramadan, which would be more than 10 days before it took place. So you're drawing a distinction between notice of hearing being given by the court on the one hand, and actual notice of the hearing, factual notice of the hearing on the other.
Indeed, sir. And so
I must say, I find that a very unattractive argument, Mr. Taylor, because courts of appeal don't exist for the purpose of deciding whether nice points of technical procedure have been adhered to. Courts of appeal exist in order to ensure that there's no injustice. And injustice involves an assessment of what actually took place and an assessment of whether it would have been any different if there'd been any difference in the course that was followed. So are you seriously suggesting that there would have been some difference in the line taken by Ms. Al-Jaber if the email which she had received if the form in which she had received notice of the hearing to take place on the 4th of June came from the court instead of some other source? Are you asking us to infer that?
No, Your Honour, I'm conscious.
Well then, how could it make any impact upon the outcome of the appeal then?
Well, here is what one's got to disaggregate are what I accept as a fully technical point, that in order for service to be lawfully effected in Abu Dhabi by email, that must be done by the court. That's the technical point. I entirely accept that in terms of the natural justice point, the question and the typical formulation is whether notice of the proceedings was received in time for the defendant to be able to prepare their defence. And that is a formulation which one sees, for example, in the Brussels Convention. It's the formulation which Your Honour will have seen, perhaps a shifting one, in connection with reciprocal enforcement of judgments between Australia and the United Kingdom, for example. So that the position is that even if there has been good service, if the defendant has not appeared, and of course appearance in the wording of those treaties should be read as not acknowledged service, given the changes of procedure, then that is a good reason for the judgment not to be enforced. And when there have been such cataclysmic consequences that have followed from the decision not to adjourn, and whether in sum and substance it is, I quite accept that if it was at the end of the Ramadan or 20th of May, that should have given time for them to instruct lawyers. There's an understanding that a power of attorney would be required, which as Justice Al-Madhani will know, were it in the courts in Abu Dhabi would be an absolute requirement. It's a requirement in arbitrations in the UAE. In this international court here in the DIFC, it is not, but that would be a perfectly understandable reflex that it would be necessary for Mr. Al-Jaber, who was a vulnerable person, that is in the evidence, in Abu Dhabi, in the middle of a pandemic, to attend a notary public, to grant a power of attorney. That would have been the assumption. Now, it's against that background that what one is really looking at is that the point at which there was legally effective service under UAE law, given the mandatory provisions of federal law, was when the court gave notice on the evening in response to Mr. Al-Jaber's email on the evening of 3rd June, that the hearing would indeed go ahead the next day. That was the gap.
Right, so there was effective service before the hearing and before judgment.
There was effective service by email at the evening of the 3rd of June.
Right, but you say that the court should allow the appeal because that's not enough notice, even though, as a matter of fact, much greater notice had in fact been received. That's the proposition, is it?
And more particularly, this arises, as Mr. Montague Smith, my learned friend, rightly disaggregated a service point that has been made in relation to what he describes as a glitch in the rules about what was said in the covering letter and the need to file a defence.
No, just answer my question.
So the question I ask is that yes, because this is part and parcel of why the matter should be referred to the Union Supreme Court for consideration, of why the threshold point arises, and why, why, in my respectful submission, since this is the court of final appeal in the DIFC, that the threshold test should be that unless a particular law, in this case, the question is whether service as permitted by the DIFC rules is lawful in Abu Dhabi, unless that is plainly so, and that there is no seriously arguable case to the contrary.
Mr. Taylor, if you allow me, please.
Yeah.
In your assessment, what you want the Union Supreme Court to do is to supervise the DIFC court in its application to its service rules, or you want it to double check the constitutionality of the DIFC rules in service against a federal laws? What exactly you want?
Well,
you want this court to do? It would be very problematic if you want the Union Supreme Court to supervise a DIFC court in the conduct of its own rules. I would say it might be that the DIFC has made a mistake in serving its claim form outside its geographical scope, but that would still a domestic thing that this can be subject for the Court of Appeal, and the Court of Appeal could have correct this. So I would say until this point, this would be a domestic problem internally. And if you want to say the service rules in the RDC are against another superior law at the federal level, that is something else. If you want to go to that far, what that will make the whole of the RDC are a constitutionality problem, because most of the RDC are not similar to the UAE rules, whether in service, case management, cost recovery, and everything. That is another problematic level, Mr. Russell. You need to be very specific and very
indeed. If I may address you very shortly on that, because it remains my primary position that this appeal should succeed, and that a reference to the Union Supreme Court is wholly unnecessary because nothing will turn upon it.
Please.
But as you, Your Excellency, have absolutely correctly said in your judgment, and I can remind you of it, but you drew attention to Article 151 of the Constitution, and you explained what a constitutionality assessment by the Union Supreme Court is, and what it does under that clause, which is the supremacy clause of the Constitution, is it goes through an exercise of statutory construction to say what is the meaning to be given to an emirate law so as not to bring it into conflict with the law of the Union on the same subject. There are similar provisions in the US Constitution and the Australian Constitution and so forth. That is the exercise that it would have to do, and all I would say is that unless this appeal is going to succeed, if what is critical to the outcome is the question of whether service was properly effected in Abu Dhabi, that would be a matter that ought to be determined by the Union Supreme Court. It's as simple as that. But I say, and I don't want to detain the court on it, because in my respectful submission, for the reasons advanced by Mr. Flynn, this appeal should succeed in any event, and there would be nothing other than a purely academic question to refer to the Union Supreme Court. If the Court of Appeal doesn't wish to readdress the question of what is the correct standard, which Your Honour
I do,
described.
Mr. Russell, believe me, this is the last option. I understand what you want the Union Supreme Court to check the DIFC service outside jurisdiction, but I ask you, is that whether the review would be to the DIFC application of its own rules, Part 9 particularly, or the constitutionality of the Part 9 rules in service against another superior law within the UAE, and on what basis? You gotta pick one of these two bases that the Union Supreme Court.
Your Honour, very simply this. Pursuant to Article 119 of the Constitution, the service of process, as well as extradition of criminals, but the service of process from a local court in Emirate A upon the territory of Emirate B is a matter that is within the sole, exclusive, legislative and regulatory competence of the Union. And so it is on that basis that only Union law can regulate. For example, the ruler of Sharjah could not make a rule that saying if you nailed the claim form to the court door in Sharjah, that would be effective service in Al Quwain. So that's the specific point of constitutionality, is because solely the service of proceedings of local courts from one emirate in another is exclusively within the competence of the Union, both legislatively and in terms of regulations. That's what it comes to.
Thank you.
Okay, thank you. Is there anything else? Anybody else wants to address? Mr. Flynn, Mr. Montague, you have finished with, or Mr. Flynn, you want to say something else?
I think only if Mr. Montague Smith has finished.
Thank you very much, Mr. Flynn. Just 2 points arising out of that. Sorry, and I won't be long. Firstly, my learned friend's suggestion is that his client only received notice of the hearing the day before it took place. And I recognise that the court's sceptical about the relevance of that, but I don't want the court to go away thinking that that might be the correct position. There is actually in the bundle an email to his client from my client prior to the one that he mentioned, which is dated 28th of May, so a week before the hearing. That's on page 1504 of the bundle.
But I think, Mr. Mont, the point that Mr. Taylor is making is that the first effective notice was that from the court. He accepts that there was prior notice, but that's the first effective notice from the court.
I'm sorry, I misunderstood that then. Yeah, no, I had been listening. I mean, I think though that is still vulnerable to the point that I was making, which is that when she attended the hearing, Ms. Al-Jabir said we received notice in the last week of Ramadan. That cannot have been a reference.
But again, I think but she's referring to factual notice rather than notice from the court, which is the emphasis that Mr. Taylor is drawing upon. But what do you say about the proposition that the law with respect to service in an emirate other than the emirate of the jurisdiction is exclusively the province of union law?
I say a few things. Firstly, that is based on Article 119 of the Constitution, and what that says is that the federal law will regulate service of proceedings between courts of the Emirates. But then Articles 120 and 121 go on to say these are the things that are within the exclusive competence of the Union, and they set out a series of things. And so Article 119 doesn't set out what's in the exclusive competence of the Union, because if you go on to Article 122, it says unless a matter is provided for in one of the two previous articles, the Emirates can legislate about it. So there's that's the first point, is that Article 122 of the Constitution gives the Emirates the right to legislate on anything that is not in Articles 120 and 121. So it's no good relying on something in 119 to say that it's out with the competence of the Emirates. The other point to note is one that is long litigated in this court, and I appeared in a case now called Fisk and Firmin in front of His Excellency Justice Ali Al-Madani when it was first decided, and his judgment in that case has been repeated numerous times at Court of Appeal level in the IGPL case most particularly. The point being that within Article 121 of the Constitution you find a carve-out which says that the federal law can say which federal laws do and which do not apply within the free zones. And then you've got the disapplication of civil and commercial laws within the free zones. And so what you see within Articles 120 and 121 are exclusive legislative competence being given to the Union over a very wide range of things, including civil procedure, including companies law, including property law, for example. But that is all subject to the carve-out, which you find in Article 121, and you find in the federal law implementing the free zones, which says basically anything that's civil and commercial isn't included. And so it gives the right to the Emirates to legislate on those issues. That's how it works. And then even within IGPL, you see the finding that civil procedure is civil and commercial, the whole of the civil procedure code. And then the final point is that there's some sort of kind of overarching argument that somehow there's an infringement of sovereignty by service out, and that somehow the DIFC would be doing something in other Emirates by recognising service out. But of course that whole premise is just wrong, because this court is simply assessing activity of parties to determine whether or not that's sufficient notification of a case. It's not doing anything in those other Emirates any more than it's doing anything outside the DIFC when it decides a case about events which take place outside the DIFC. I think if the argument was right, I think where it gets to, Mr. Taylor's point, would have to be that the only way you could serve DIFC court proceedings in another emirate would be serviced by the court. And that would be much closer to actually the court doing something outside the DIFC. When it's party service, that seems to be his complaint. When it's party service of proceedings, all the court does is it says, looks at what the party has done and says, yes, that is sufficient, or yes, no, it isn't. It's not doing anything outside its borders. There are a range of other points, but I won't labour them. But that's a summary of them.
Thank you.
Thank you. That's it, Mr. Montague-Smith.
Sorry, I was fumbling for the button. Yes, that's it. Thank you.
Thank you very much. So now, Mr. Flynn.
Yes.
Before I go to Mr. Flynn, Mr. Taylor, is there anything else you want to say? Have you missed something that was raised by Mr. Montague-Smith?
Your Honour, a single point, and it is in my skeleton, but what Mr. Montague-Smith's analysis, sorry, I can't, is my video, sorry, it is. What Mr. Montague-Smith misses out is the unique feature of the UAE constitution, which is that if you look very carefully at Articles 120, 121, is that in purely federal matters, the Union is given both legislative and executive competence. In the matters in Article 121, which include civil procedures codes, they're only given legislative competence. That's why the Union Civil Procedures Code had to be implemented by Dubai legislation in Dubai. In contrast to that, when it comes to cross-border service between what was 7 separate sovereign states, Article 119 puts both executive and legislative exclusive competence in the Union with no derogation. That's the point that he's missed out. But that is in my skeleton, and I don't want to labour the point.
Okay, we note that. Yes, Mr. Flynn?
Right. I know it's getting late for some members of the court, so I'm going to be as brief as I possibly can. I want to.
I'm so sorry to interrupt. I do apologise, Mr. Flint. I've just been told my solicitors have been booted off the call. They don't have anything to say, but they are trying to get back in, and I do apologise. Would it be possible just to pause? I don't want to extend this either, but pause for 30 seconds just to see if they can get back on.
Please take your time.
I do apologise. I think I. Oh.
Yes.
I think I see Mr. Ironmonger who's back online. I think we're just going to have to crack on, I'm afraid. Let's carry on. I apologise for the intervention. I think I'll just have to keep an eye.
Okay, Mr. Flint.
I want to start with picking up on a point made by Justice Martin, and that is, what is the issue for this court? And the issue for this court is, how do you do justice between these litigants on this appeal and for the purposes of future litigants? And at the heart of this appeal, there is a simple question, and it's this: is there a requirement to give a last forward-looking opportunity to repay a mortgage before a final order for foreclosure is made and title is transferred to the bank or the lender? That's at the heart of this case. Now, I've made my submission.
Mr. Flynn, who are the litigants on this appeal? Because, well, first of all, let's start with Omniat. You told us earlier that Omniat, you contest the proposition Omniat's a shareholder. Do you still maintain that?
I do. I was about to come to that because I need to take it in stages. The answer is this: there is evidence that at one stage Omniat was a shareholder of Al Rihab. You saw that. It's no longer a shareholder and hasn't been since the 15th of November 2020. And Omniat 1 is not a party to the proposed sale agreement. That is a different company. So the point is that, and I'll come to that because I think one has to take it in stages. If one takes it in stages...
But you're taking instructions from the Omniat, aren't you?
My client is Al Rihab, but there is a conduct agreement over which I think it's Omniat 1 has the conduct of this appeal. Yes, it's Al Rihab have given conduct to others. You're quite right about that.
And so when we talk about justice between the parties to the appeal, we've got to include Omniat in that, don't we? Because Omniat is, to all intents and purposes, Al Rihab for the purpose of this appeal. And it's maintaining the appeal because of the benefit it sees in the agreement.
And the question is there a principal reason why that shouldn't be done? Because the issue of principle in this case is, should you be given a last forward-looking opportunity? Now, if you're with me on that, then so much of the appeal falls away. In fact, we submit that we succeed. The only issue then is the form of the order and the time.
But do you put that as an absolute? Sorry, Mr. Flynn. Do you put that as an absolute proposition applicable to every case in the DIFC? Do you? That there has to be a last forward-looking opportunity to redeem.
I put it in two ways, which is, yes, I do put it in that way. In other words,
well, there's nothing in the law to establish that, is there? Nothing in the Dubai law, DIFC law, to establish that.
There is nothing either way. You're right. It's a broad proposition. It's a bit like saying the court can grant an injunction. The question is, what are the limits of that jurisdiction? The court is free to do either way. I accept that this court can reject that point of principle. This court can say, in the DIFC, you do not get a last forward-looking opportunity.
Or the court might say, in the DIFC, it all depends on the circumstances of the case.
Right, I'm coming to that. Let me take it in stages. I'm coming to that. But that is the point of principle. That's the first point of principle. And my submission, which I've laboured at length, I've put it in writing, is that there is such a forward-looking requirement. There are safeguards. That's why the orders for foreclosure are extremely rare. They're very rarely made indeed. And if they are to be made, in my submission, there is always that last forward-looking opportunity in the DIFC. Based on my submission.
What's the English law on this? What's the English law on this?
Yes, that is the English law, which is you will get 6 months.
It's the English practice. Isn't it more correct to say it is the English practice?
Yeah, English practice.
It is, but I would go beyond it being mere practice, if you so mean. It's embodied in court rules. The standard form, for example, has written in it 6 months, and that in my submission elevates it to if I could put it this way, a mere point of procedure.
But then again, we get to the problem. Sorry, Mr. Patrone, we get to the problem that you're talking about order nisi, and order nisi doesn't work in a torrent land system. Why would we import a process from a different property-based system into a torrents-based system?
Yes, can I address that? So the issue of principle is this. This is the question. I want to make it clear what the question is. Should there be a last forward-looking opportunity? Now, in my submission, based on English law, there should be. The only issue, and if you're with me that is a matter of principle, the only issue is the form of the order and the time. And it's not right to say that you only have evidence of English law, because the textbook that we've given you, Fisher and Lightwood, very well known, sets out the position in Ireland, New Zealand, Canada, and so on. And in my submission, it's very clear that these orders are rarely made, and the safeguard in my submission includes a forward-looking opportunity. Now, if you're with me on that, so let's just take it in stages. If you accept that a submission, then it's only the question of how much time do you follow England, or do you give more or less in the circumstances of this case, and what is the form of the order? Now, can I just say on the form of the order, I was dealing with the proposition which Justice Martin put to me, which is an order nisi doesn't work. Now, I don't accept that is clearly the case. We need to take it in stages. The reason I say that is this. The form of an order nisi is the court, subject to a condition on the nisi, will make the order absolute and transfer in the future. And what I think, Justice Martin, you were putting to me was the proposition that what happens after the expiry of the mortgage if there's a sale which doesn't repay the lender. Now, the issue is, and I can't tell you the answer one way or the other because I don't know. It's not English law because we don't have a torrent system, and I don't know what the Australian law is. But the question in those circumstances would be, what happens if there is such a sale and the EMBD are not paid off? What happens when the date absolute in the order occurs? Now, it seems to me it's perfectly possible that having the nisi order on the register, that if there is a purported sale which doesn't conform to the conditions in the order nisi, that the order transfers the title to the lender. So in this case, EMBD. In other words, I don't accept that it's absolutely clear cut that an order nisi doesn't fit with torrents and wouldn't transfer title if the conditions weren't met. But my submission is, sorry, Justice Martin, I can't hear you.
Sorry, Mr. Flynn, that's my fault. The order nisi, how can you say that the order nisi transfers a proprietary interest?
Because
the proprietary interest isn't transferred until the conditions to which the order is attached have been fulfilled. I just don't understand that.
I agree. Let me explain, which is this. It is an order made subject to conditions. So the order nisi is necessarily, it doesn't transfer title at that stage, but what it does say is, unless certain events occur, that would be full repayment of the outstanding debt to the lender, then title is transferred to the lender. So in other words, that is what would be registered. Now, if some other third party...
But you can't register it. But you can't you can only register proprietary interests, and that's not conveying a proprietary interest.
Well, the question is it a contingent interest? I mean, I totally accept
proprietary interest.
It's got the potential.
You couldn't register it in Australia.
Right. Well, I can't argue with that. But
I don't know if you could register in the DIFC, but I would be surprised.
Well, so I'm dealing with on two hypotheses. If you're right, I mean, I accept what you say about the Australian position. I can't gainsay that. But there is a fundamental question, which is a contingent order which says that title will be transferred unless something happens. Can you say, well, even if there's a sale in the meantime, the order takes effect? In other words, the new buyer has the title taken away from them by order of the court. And if that is the case, we're back into nice side. If we're not in that case, then we're back to the submissions on, well, you make an order absolute with a caveat. But the point about that is it's about justice. It's about whether or not a forward-looking last opportunity should be given in the DIFC. And in my submission, it plainly should. The issue is really about how much time. And if you're with me on that, I accept also that you're right. The question is, well, what should you just blindly follow the English position of 6 months? I do say it's more substantive than procedural in England, but what needs to be given is an opportunity to make the sale. So as long as the period is sufficient to give a genuine and reasonable opportunity to make the sale, then that's it, and that should be given in my submission. And there may be factors that impinge upon that. Now, if you're with me this far, so if you're with me that is the principle that
Mr. Feeney, if there's a particular case in which the court is satisfied that there has been a genuine and real opportunity to make a sale over the last 3 years, why would the court give one more opportunity? How do you answer Mr. Montague-Smith's point about there being no magic in backward looking as opposed to forward looking? Why would you give, if 3 years have gone past without anybody taking any step to sell and redeem the mortgage, been in default for that long, why would you have to give them one more chance? Why would we impose that as a necessary obligation upon the making of a foreclosure order?
Because I would turn the point you made to me earlier, which is that the DIFC law doesn't say either way. As I understand the Australian position, there are safeguards. If you know that if there's been an outstanding breach for a particular period, and that you will be subject to an order foreclosure in defined circumstances, which are certain, that you know about, you could have such a system. In my submission, that's not the system you have in the DIFC. There's nothing in there to safeguard the owner of the land in relation to foreclosure as opposed to breach. So no one suggested that anyone knew that a foreclosure order could be made in these circumstances. And that's why in my submission, there should always be that last opportunity given to make the sale. And here,
Mr. Slim,
yes.
Why is there a date provided in the mortgage that the property must be redeemed by a certain date? Why a date has been fixed there? Because in Malaysia, what we do is normally have an agreement is that the mortgage continues until the debt is paid.
Yes.
Until the bank or the lender allows the lender the borrower to redeem the property, or releases the borrower from the charge. Here in Malaysia we call charge, we don't call mortgage. Why is a date fixed there? I cannot understand that part of it.
I have to confess that I find it very unusual as well. I don't know why it was done in this particular case, but the fact is that is what has happened. You may find in other cases that the Malaysian position, and indeed the normal English position, is exactly as you've described. But here there's a fixed date. Now, what I would submit in relation to that is that can't dictate whether or not what the answer to the issue of principle is, which is, should you simply say, well, that's it, you breach the terms of the loan agreement and the mortgage, therefore title is transferred. Now, in my submission, that would be very, very harsh indeed. I would submit it would be very surprising for the DIFC to take that and not give any further opportunity to a defaulting borrower for their title to be transferred without further notice, or indeed on this basis, no safeguards, because there are no
that is not, in my submission, not an appropriate approach, and that there should be a last opportunity.
Okay, is there any guidelines according to the English cases where the ordinance is given? What sort of circumstances is given?
Yes.
Is there any decision that gives us a guideline on how it is to be decided?
Chief Justice, can I put it this way? One of the difficulties that orders for foreclosure are extremely rare. So it's not as if there's a vast lot of case law. We've given you the English case law, and the bottom line on the English case law is if the court is going to make a foreclosure order at all, there are genuine and proper safeguards, and the answer is you get 6 months to pay. That is the rule. You get that extra period, notwithstanding any prior breaches, and notwithstanding how long it's gone before. I mean, I could turn, again, the points on the facts. I think this is more a point of principle on the facts. But the Emirates MBD had every opportunity to exercise their power of sale, to make this application at a much earlier stage. They can't pray that in aid of the position that we're now in. But ultimately, it is a point of principle. What is the position in the DIFC? Are there safeguards or are there no safeguards? And if so, what are those safeguards? And we submit the safeguards should be along the lines or the same as those in England, which is you do get a forward-looking opportunity in order to redeem your outstanding debt. And if you're with, as I say, if you're with me on that, then actually much of the issues on the appeal fall away.
Yes. And are you going to go on other issues that be submitted by Mr. Smith?
I don't want. No, I just want to say a little bit more about this issue because it is so fundamental. Justice Martin has asked, well, why should the court do that? Why should the court give you an opportunity? And that is because this is a draconian remedy. It's very unusual. These are very unusual orders, and there do need to be safeguards against the exercise of a power of foreclosure. And in my submission, what we have here is a safeguard of getting extra time to pay. Now, as I say, it's not purely procedure. It's not just simply the equivalent of a service or the manner of service. This is a really fundamental requirement for an order for foreclosure under English law. There have to be real safeguards. And if you don't have these safeguards, in my submission, it would be quite wrong and certainly very surprising if the DIFC simply had no safeguards in those circumstances. Now, as I say, yeah, of course, Justice Martin.
Mr. Flynn, it's still not clear to me how you say, if we were with you on the proposition that extra time should have been granted, it's still not clear to me how you say we should give effect to that conclusion. Because when we started the day, I understood.
I'm sorry, I lost you then.
Yeah, we can't hear you. We can't hear you, Mr. Judge Martin or Judge Wayne. We can't hear you. We can't hear you. Judge, what's going on?
Could I maybe answer the question I think Justice Martin was asking me, which is what is the remedy that we seek on the appeal? And the answer is this. The first remedy we seek is that the appeal should be allowed and the order for disclosure should be overturned. So there should be, foreclosure should be overturned. And that's our primary relief. We haven't given that up, but I accepted in argument that the consequence of that would be that it would affect the security of EMVD.
It's all.
Yeah, we need to Flynn too. Yeah.
Yes.
Do we have Justice Martin?
I do not know.
It appears to me his line is cut now.
Okay. Justice Martin, we have lost. Can you check what's going on? Cha, are you there? Alia? Everybody has disappeared.
I don't think we have Justice Martin at the moment, do we?
No. I've told the IT people to check what's going on. The COVID in case in Malaysia has gone up to 3,000 yesterday, the last 24 hours, which is the highest.
Yeah, we're doing very badly in the UK.
Yeah, I know, but in Malaysia, 3,000, which is the highest that we have ever reached. Problem is you have to balance between opening the economy and restricting the disease.
Right. Can anybody hear me?
Yes,
yeah,
Justice.
we can hear you now, Jess.
We'll come back.
Right, okay.
What
Okay,
happened?
good.
I thought you disappeared for a while.
I don't know what happened there, but I went out and had terrible trouble getting back in. But I've tried, so I'm very sorry about that. So
Okay, it's
at all.
okay.
I'm sorry.
Now, okay, Mr. Flynn, can you proceed?
Yes, could I just, before I know Justice Martin was about to ask a question, before I do that, can I just make it clear what the link is between the DIFC law and English procedure? Because the RDC Rule 210, which is in the bundle at bundle 3, tab 11, page 1298, I wonder if we could get that put up. Whilst I'm waiting for that, I'll just tell you what it says. If no provision is made or no appropriate form is provided by the rules or any law enforcing the DIFC, the following rules of practice and procedure shall be followed and adopted. Such rules as shall be have been enacted. To the extent that no rule or practice direction dealing with the matter shall have been enacted with regard to the court of first instance, the guide, together with any prescribed forms with such changes as the court considers as appropriate to be applied in the circumstances. Insofar as the guide doesn't deal with matters or make reference to the CPR, together with any prescribed forms with such changes as the court considers appropriate to be applied in the circumstances. So what we submit is that there's no appropriate form provided for a foreclosure order in the RDC, nor does the guide deal with it, and therefore the rule 210.3 is that the rules of practice and procedure contained in the CPR, together with prescribed forms, with such changes as the court considers appropriate, should be followed and adopted in relation to foreclosure orders.
You're very bad. I can't hear what's going on.
There is a direct route, Justice Martin, into bringing in the English rules, the six. Can you? I'm not sure whether it's my end because I seem to be.
I missed the last sentence or so.
Did you get my point? That the point is that the English rules come into the DFC law by reason of Rule 210.
Well, I understand
Right.
the proposition.
So our point was no appropriate form. Yes, you got it. Oh, I'm grateful. So that is so that really.
How long more you need to take, Mr. Flynn?
You'd accept it in what sense? I'm sorry. That it doesn't follow that.
Mr. Flynn,
I think
how
only a
long-
few minutes. I just want to
how-
deal with a few issues, but not many.
Well, Mr. Flynn, I wonder if I could get back to the question that I was asking when I dropped it.
Yes, of
But
course.
so I'm just not clear what you say we should do, because this morning you said we should effectively create an order ISI procedure. Then following our interchange, I thought you'd lost interest in that. So I just want to be clear what you say we should do.
Yes, of course. So the first point is that we say that no foreclosure order should have been made at all, and therefore you can set aside the order for foreclosure. Now, I also
destroy the bank's security interest.
Yes, that is the consequence, and I accept that is the consequence.
I think you can reasonably assume that it's very unlikely that I'd be joining in making that order, Mr. Flynn.
Okay, I understand that. I'm just taking it in order. So the next issue we raised was the order nisi, and the order nisi, I accept there is an issue if it doesn't create a security interest in REM, which would bind third parties. Then there is an issue, and I think you said that's the position in Australia, and I can't gainsay that. So then we come, and if I'm wrong, so if your lordship is right about that, we then move on to the next proposition, which the only way in which to deal with it is to have an order at absolute with a caveat. And in principle, in my submission, that satisfies the issues of procedure and substance, because
I think we and the respondent are entitled to more than principle. I think we need to know from you precisely what order or orders you say we should make, and support that proposition with any submissions that you wish to do. Because
I agree.
I don't think it's good enough to talk. So how long would you need to do that, do you think?
I'm in the court's hands. Obviously, we want to do that as soon as we can. I was going to say by close of business on Monday.
Yeah,
I think
today is.
that's
So you're working on today is Thursday, Friday, and you have Friday and Monday.
Yeah.
Yes. And then I was going to suggest that we get a response by the end of the week, so by close of business on the Friday. That's the English week, though, I accept that.
Mr. Montague-Smith, are you still there?
Yes, I'm still here, if you can hear me. I think that should be fine. I think that's fine.
Okay.
The only other issue, yes. The only other issue is we would like, and obviously with normal discipline, but we would like the opportunity to reply, because what will happen is we will present our order, we will explain why we say it works, and what will come back is, I hope it will come back and say, yes, it's agreed, and we agree with that approach. But I suspect that's unlikely, in which case I think it would be useful to the court for us to respond, albeit briefly, to anything that's said against us. And I would ask for, again, until perhaps, could we have until, so that would be Friday of the following week, and then could we have until the Wednesday of the following week to do that? So all submissions are in by that time.
Well, that sounds reasonable to me.
Speaker.
Sorry, I do have a few reservations, but I think if the court's going to go down this route, I think it needs to be quite clear what we're making submissions on, because seeing how this case has developed over time, we've got a new submission just in reply on the appeal under Rule 210.
I leave that. Can you set out what is it that you want the parties, or
what I want is the
parties to
the form of the orders sought by the appellant in the event that the appeal is successful, and any short submissions in support of that form of order.
So just as to the form.
Just to the form of the order, and any short submissions as to the form of the order. And I'm not limiting you to one order. If you want to put in, we could do order nisi and justify that by, of course, I'm not excluding that. But if you don't want to go down that road and you just want to go down attaching conditions to the order of foreclosure that's already been made, then I want to know what those conditions are, how they would operate, and why you say they would work. And that would be, Mr. Montague-Smith, you would respond to that topic and then you would reply to it. Is that understood?
Yes, understood.
Yes, all right. And so that would be submissions by Monday, submissions in response by Friday, and then submissions in reply by the following Wednesday.
And if I'm right, I think that's the 11th, the 15th and 20th of January.
Yes, that's right, I think.
So do we continue this hearing after that, or?
I wouldn't think so, Chief Justice. I would think we just deal with it on the papers.
Okay. Anything else you want to say, Mr. Flynn, before we?
No, not unless the court.
Mr. Flynn, I'm still curious about this shareholder business, because I don't understand your position there. Because we saw evidence earlier that Omniat was a shareholder back in May, and now you're telling me that it stopped being a shareholder on the 15th of November, and that it's a different Omniat company. Well, where's the evidence of all of this?
Can I just say, right, so this was another point I was going to make, which is this. If you're with me, the answer against me is this. And I think it's really what the Chief Justice said, which is, if you agree that we should have an opportunity to sell the property, we say we have an oven-ready deal. Now, our position is that is, I hesitate to use that, by the way, for those who are English, they'll know why, but it's an oven-ready deal, and it works under the subject to the consent of DIFC investments.
But it's more than oven-ready. It's a deal that commits you to one transaction, and while that transaction remains on foot, you can't sell to anybody else.
Yes.
So if we give you 6 months and this transaction remains on foot but isn't consummated within that 6 months, then the extension of time is pointless. And there's no time limit on this there's no time specified in the agreement with the Omniat party for completion, is there?
No, and the answer to your
sorry, you go.
Sorry, the answer to your point is this: that the court isn't in a position to determine this one way or the other. But as I say, if it said that this deal, this oven-ready deal, could never work, then that would be an application that would have to be made to the court of first instance.
No, that's not. I think, Mr. Flynn, I don't see it that way, I have to say. The situation is this. You say that you were unjustly dealt with back in June because you were deprived of an opportunity to sell the land. Now you have sold the land to somebody. You have entered into a binding agreement to sell the land. And you say that this court should do justice to Al Rihab by now extending the time in order for you to consummate that transaction. Because until that transaction is either consummated or terminated, that's the only transaction you can implement. But Al Rihab is not here saying that. Omniat is here saying that. And you say that on behalf of Omniat. And Omniat is maintaining this appeal on behalf of Al Rihab, presumably because of its interest in this transaction. And then we ask ourselves, well, are we being asked to do justice as between Al Rihab and the bank, or are we being asked to confer some benefit on Omniat? That benefit being obtaining the land at a price that is less than the market value that would be obtained by the bank in the event that it's sold to third parties at arm's length after a full marketing campaign, unlike what has happened. And so far as Al Rihab is concerned, it doesn't matter, because whichever way it is sold, any of the proceeds of sale over and above the bank's debt go to Abu Dhabi Central Bank, ADCB. So it seems to me on this analysis, the only beneficiary of us giving the extension of time that you seek is not Al Rihab, but Omniat. Because Al Rihab is in exactly the same position.
But it is.
So why would we do that in order to do justice between Al Rihab and the bank? Why would we confer a benefit on Omniat?
Because I don't accept that is the right analysis. Because firstly,
why not?
Because our position is that this deal that's already ready to go is at market value. Now, if you shut out that deal,
well, where's the evidence? Sorry, Mr. Flynn, where's the evidence of that? There is absolutely no evidence as to how this transaction came about. And you're telling us without taking us to it that Omniat is not a shareholder. Well, clearly it's a related party to a shareholder, isn't it?
It's not a related party in the sense that it falls foul of the existing arrangements. But I totally accept your point.
But it's not arms. But it's not. You're not suggesting it's arm's length, are you?
Yes, we are saying that subject to the consent of DIFC Investments, it would not breach any of the existing arrangements. Now, the point.
But you're saying Omniat, who stands behind Omniat? You say they are completely arm's length from Al Rihab, when an Omniat company was a major shareholder in Al Rihab in June of this year. Really, Mr. Flynn, is that what you're saying? Yeah.
Can I answer your lordship's question, which is this?
Yes.
I can't say all I'm telling your lordship is that this is all on instructions because you don't have the evidence. You have a limited amount.
Well then why should we, how can we be satisfied that we're doing justice as between anybody when we have no evidence as to the provenance of this transaction, and on the face of the materials we have, there is a clear connection between the purchaser and the vendor, and no benefit at all for the vendor if this transaction goes ahead as compared to sale by the bank.
Right. So there are a couple.
And when you're here on instructions from the purchaser.
So let me answer that in stages. Firstly, even when it was a shareholder, even in June, it was only a 2% shareholder. But the point is this, that the reason it's just to do as I submit is because the whole thrust of the case before Justice Giles was you could go straight to foreclosure. There are no issues, no need to consider the interests of any other party. What has now happened is that has transmuted into the court should take into account the interests of all these other parties on only one side of the evidence, only a partial view. And it would only work, in my submission, if this agreement could be shown to be in breach of the existing arrangements. And this court is not in a position to reach a conclusion on that. Now, as I say, that is something that would have to go back and be determined on proper evidence. But it would be wholly unjust. In my submission, it would be heaping injustice on injustice, not to provide an opportunity for this transaction to go through. What happens if it turns out that this transaction was above market value? You just don't know one way or the other.
But you haven't given us any evidence. You haven't given us any evidence of that, Mr. Flynn. And on your own evidence, the evidence that you earlier adduced was that the market value of this property was between 170 and 205 million dirham, and that if subdivided, the value would be over 350. And now you've brought up this transaction without any reference at all to its provenance, without any description of the financial capacity of the purchaser to settle, without any reference to market value, without any independent advice, and you're here representing the purchaser under that party. It just makes me very, very suspicious, I have to say, Mr. Flynn, that the court is being asked to sanction a device whereby value is being taken out of Al Rihab to the detriment of its creditors and in favour of a shareholder.
Right? Can I say?
And I think you need to persuade us that that's not the case, because that's certainly what it starts to look like to me.
But in my submission, you can't reach that conclusion, and you're right, Justice Martin. You don't have the material. It's not before the court because the case.
Well, whose fault is that?
But it's not our fault. We are the ones who are saying that the order shouldn't be made, that you should give an opportunity for other parties to come along and put their position forwards. And it's only now in the last document, i.e. the reply submissions, that we get all of this material about fairness between the Al Jaber group. You have nothing about that, about ADCB, when we were saying that ACDB should be joined as an interested party. Now, Justice Martin, if you are right in this analysis, and I don't accept for one moment you are, then Emirates MBD can go off to the first instance court and get a restraint restraining this sale. There is equally in my submission a perfectly possible position on these facts, which you don't have all of them, that could end up meaning that this deal is lost and that no better deal ever comes along. Now, that's perfectly possible. The only way in my submission that can be dealt with is for the caveat to be given, and if Emirates truly believe that this is a deal that can't be done or shouldn't be done on substantial grounds, that should be ventilated with all the evidence. Now, I don't accept your lordship's characterisation of what there is.
How does Al Rihab suffer any prejudice if this appeal is dismissed and the bank sell the property instead of the property going to Omniat?
Because what happens if the sale doesn't repay the debt?
if the new sale doesn't repay my client's debt.
Why wouldn't Omniat be as willing to buy from the bank as it is to buy from your client?
Because, well, the answer to that question is I don't know, because I don't have the evidence. I'd just be speculating. And this is all speculation in my submission. It's very dangerous. The parties have been negotiating. It's obvious that that's the position. And they haven't been able to reach a solution. Now, it's very worrying that it could be out of the frying pan into the fire. As I say, if that analysis is right, I don't accept for one moment you can properly reach that conclusion on the basis of the evidence. But if that were to be the case, then they could go off and get an injunction, and in the light of all the evidence, take it so that the court can have full evidence on this.
But it's really relatively simple, Mr. Flynn, because under the agreement, which is in evidence, under the purchase agreement, after paying ENDB Bank, and the DIFC Investment Corporation, all the proceeds go to the Abu Dhabi Central Bank. That's under the sale that you want the opportunity to consummate. That is precisely what the bank also propose under the foreclosure order. The difference is that you are selling at a price of $108 million to a purchaser who you here represent without any evidence that that is market value, and contrary to the earlier evidence that your side introduced to the effect that the market value of this property was between 170 and 205 million dirham, so that on that analysis, on what limited evidence the court has before it of value, there is a sale at undervalue, no material difference to Al Rihab, but a benefit to the purchaser, Omniat, who is giving you instructions. Now, I just don't see, on that analysis, I don't see how we, by allowing this appeal, we would be doing justice as between Al Rihab and the bank. That's what I'm struggling to see.
The answer is, if Mr. Montague Smith said a very revealing thing, and I don't disagree with it, there is more to this than meets the eye. And you only have very limited evidence. What you now have in the reply submissions is reference to Al Rihab being the guarantor of the Al Jabba Group's debts, the amount of that debt. You have old valuations, you have the oven-ready deal, you have very limited material on which to reach a conclusion one way or the other. Now, the point I'm making is that if you will not be doing justice between the parties by preventing my client from making the sale. The only issue would be the one you've raised, which is if in the circumstances it is so that either it breaches the existing arrangements or there's some issue about market value, which we don't accept, that has to be ventilated in my submission on full evidence. And that is what we were asking for, or my clients tried to ask for at the outset. The irony of the case I'm now having to meet is that we were asking for the opportunity to make submissions, and we were saying that interests of others should be taken into account. But that wasn't done. Now we're on the appeal. In the very last document, the reply submissions, the court has over 30 paragraphs of background material, giving only a partial one-sided view. Now, I accept you don't have all the evidence, but it's in my submission, the answer to that is it's not my client's fault.
I think we are going over and over the same issue.
Understood.
If you don't, unless you move to another subject, I think we will adjourn for the day.
I'm very grateful. I just really wanted to deal with that, only that point, which is, in my submission, should be very dangerous to infer.
I understand your point.
There's more to it than meets the eye, is what I would gratefully adopt my learned friend submission. And therefore it's dangerous to jump one way rather than the other.
I had nothing else. Judge Wayne, shall we adjourn for preserve our judgment? And Judge Ali? I think our line is broken again.
Yes.
We'll adjourn this case, and we'll fix another date to deliver our judgment once we are ready.
Yes.
Okay.
Thank you. Thank you, everybody.
Much.
Bye.
Good night to you, Jane Wayne.
Good
And
night.
good
Thank you.
afternoon to
Thank you
you.
very much. Thanks, Julius.
Thank you.
Thank you, Mr.
Thank
Flynn.
you.
Thanks,
All the
Mr.
best.
Smith, Mr. Taylor. Thank you very much all.
Thank you.